Good morning, good morning, good morning. It's Thursday, May 29th. It's day 23 of 6,897 of the Karen Read Retrial. We are in week 6. Yesterday, when we left off, there had been a voir dire very quickly to deal with whether or not the defense would be able to ask Dr. Welcher more questions about Dr. Scorti-Bello, the coroner, and about Trooper Paul. And if you watched today's case brief, you will see that we took a look at the things that I thought I remembered from where things were placed on Trooper Paul's layout versus where things were placed on Dr. Welcher's layout. And did he rely on Trooper Paul? And what does reliance even mean? Emily, are lawyers going to fight over what the word rely means? 100%. Does rely mean that he made his decision based on that decision? Does rely mean he looked at those pictures? Does rely mean that that's where he got the location of items from? Does rely mean that that's where he got the photos of the inside of the car or the mileage from? What does rely on it mean? Even if he came to independent determinations with independent testing, were there still parts of what Trooper Paul did that he relied on, allowing the defense to then ask more about Trooper Paul's report? I want to see how the court rules because this witness is probably going to be on the stand at least the rest of today. Remember, today is a half day, so no lunch in court today, just a quick morning break and a half day. And then will this witness be done today? I don't know. I really don't know if this witness is going to be done today. We might go into tomorrow, and tomorrow is supposed to be a full day in court. We'll see if that changes. So for now, let me know where you're coming in from, what you're drinking. I got a freshly made cappuccino. I am ready for all the things. Law nerds, are you ready for all the things? It's live court time. It's just hear ye. Well, we're not going to get that yet because, well, we're going to get argument first, I would imagine, because that's what the court told the lawyers they could do. So we're going to go to that first, and then we'll
bring the jury
after that. So let's roll the intro. Let's get to court, shall we? I think so. We need to go. It's time to go. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Let's go to court. That's not the layout I wanted. There we go. It's time for court. Emily, are you trying to hype yourself up because you're exhausted with this witness? Yeah, a bit. Are you? I think it was a lot of being extemporaneous.
All right, good morning, counsel. Good morning, Ms. Reed.
Right? It's just a lot of stuff.
All right, Mr. Lessie, I will hear you on your argument on the voir dire.
Wait, was that a sneeze?
Thank you, Your Honor. I'm just loading up my computer.
That was the highest pitched squeak. I mean, not to judge somebody's sneeze, but it sounded wild from over here. It was...
Your Honor, I am going to address the Trooper Paul aspect.
And then I'm going to address the Dr. Scorti-Bello aspect of Dr. Welcher.
I appreciate a laid out argument, sir.
With regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents, and the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself. They show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665,
okay,
and I respectfully request the court to anchor into that odometer reading because I'm going to show the...
Leslie's like, Your Honor, lock in, Your Honor, because he used it.
Path that odometer reading takes through all of the documents, but I want to emphasize the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis the starting point for his determination of the locations and times for the events of January 29 of 2022. Dr. Welcher uses his scenario analysis of Ms. Reed's travels, and that's detailed on slides 24, 25, 26, 27, and 28 to calculate and then deduct 36 miles from the odometer according to Trooper Paul on February 1st of 2022 to arrive at an odometer reading of 12,629, which obviously is different from the anchor I talked about of 12,665.
So he used the mileage from Paul.
So the assumed odometer of 12,629, again, is based on Trooper.
This is a critical point for the defense, because if Welcher used Trooper Paul's mileage to tag where key cycle 1162.2 happened, then you can't have the analysis of when 1162.2 happened, mileage-wise, without using Trooper Paul's data.
Paul's cars
that makes
analysis
sense to me.
In slides 22 and 23.
And that's just information that
are then used as a tether,
retained.
A connection to the events recorded by the VCH in the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are
together a lot
in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. Two more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.paul. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity. He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360, here's the key, to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis and adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29,
I thought that they didn't use the drone, and we went
Lieutenant
back.
O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone.
Right.
And I
it was dark.
Again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but the point, whether Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless Your Honor has any questions, I would now move on to
I think that's pretty clear.
Dr. Scorti-Bello. Thank you.
I think it's pretty clear. The reason that Alessi is making these arguments is because he wants to be able to ask Dr. Welcher more about Trooper Paul's report. Trooper Paul's report, if it was not relied on, is hearsay and is not coming in through that witness. He would have to call Trooper Paul. But what Alessi is trying to show is that it was used and relied on, and therefore you can ask anything you want of Dr. Welcher, because you know what the defense wants to ask. You reviewed Trooper Paul's report, and it had this other determination and this other time and this other key cycle, and he wants to be able to get into all of that.
Much shorter.
Because of course he does.
Mr. Woke, do we have the slide of the Dr. Scorti-Bello it's at the end of the slide presentation with her name on it? Oh. If you could just give the slide number, please. So it is slide 131. I almost know it verbatim, Your Honor, so I will continue if Ms. Gilman has slide or someone.
Your Honor, I've had to look at this slide so much.
Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious. His rooting in this document and reliance upon it. Why else would he have it in his slide presentation? Right. And he's got the name of Dr. Scorti-Bello. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him. Then you go to underneath cause of death, blood impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wilk, just go to the right. And so you've got highlighted head, skull fracture radiating from the right occipital skull and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, that the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green, the LR, because I've never seen this green highlighting before. And it could also be Dr. Scorty Bellows. That's another possibility. I'm not sure. But let's assume sort of the most conservative part that it's Dr. Scorty Bellows. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But in it, it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it, and there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted. But it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination, if an expert says or even infers, I reject this. I reject what Trooper Paul did, or I reject what Dr. Scorty Bello did. That is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it? And that applies to both Trooper Paul and Dr. Scorty Bello, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Trooper Paul, which is completely false based upon what I just showed. But even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it. And the same with Dr. Scorty Bello. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it. What I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scorty Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162-2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head-on in the first proceeding. We're not coming up with some fanciful ghost in the second trial.
He's so animated this morning.
Gone through extensively in the first proceeding. And I understand this is a new trial. But it goes to show it's not something coming out of the blue, etc. And with regard to Dr.
This is not a new theory.
It was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner
he might not be able to
says,
get into the medical examiner's opinion that much because the medical examiner's opinion is separate.
Motor vehicle impact injuries.
It's not a legal conclusion.
There couldn't be anything more
that they can get into.
more probative then whether or not the injuries to the
You gotta
decedent
kind of split that up.
are
there.
from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to, respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. Right. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorti-Bello's autopsy report, cherry pick things that benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd. And it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So
yeah, you can ask about the ME's injuries, what the ME said, what the ME said about them being consistent or inconsistent.
And her team,
yeah, 100%.
Be allowed to exercise their constitutional right to cross-examination.
Determination.
The keystone of a defense
maybe
in
less.
A criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
Undaunted from all the interruptions. Fair.
What arises from the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law.
It is too early for me to have any fucking chill with anything. And I know that I am the worst hypocrite when it comes to mentioning anyone's pronunciation of anything. I understand that the hypocrisy runs wild because your girl can't pronounce shit. But what the fuck is usurping? It is so distracting. The nefarious and the usurping and the Mr. Elisi. Sir, stop it. You're going to break my brain early in the morning.
What arises.
And it is so starkly noticeable after the king of Scrabble, whom dictionaries fear, has just given arguments.
From the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer.
It's
and
cross-examination.
The court knows what they're trying to do. They're trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness.
When you change witnesses in a retrial, you run this risk. And as much as you tell, and this is my speculation, hear me now. If I see anyone saying EDB said, no, EDB speculated that the prosecution said we need a full new report, not reliant on anything Trooper Paul did. Speculation. But when you use a new expert and this expert reviewed and relied on the other expert, it can be asked about. You know that going into a retrial. They can be cross-examined on it. Now they can say, I didn't find any of that credible. That person sucked. Okay. But they get to have the conversation on cross.
Have asked Dr. Scorti-Bello what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful.
Did the expert use
Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion.
The rules for experts are different.
That's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scorbello's conclusion that this cause of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified.
He should have to explain it, though. The witness should have to explain why he would discount the ME's testimony. And the ME last trial, not this trial, last trial, the ME said, I'm not going to determine whether this was a vehicle collision. I'm not a biomechanical engineer. I'm not determining that. I'm just saying this isn't consistent with what I've seen. But yeah, she's qualified to determine manner of death. And I wonder if the fear is that Dr. Scorbello came across as a really reliable, neutral, factual witness. Just right down the middle there. Yeah, this is what I determined.
Of that. And so this is a simple game. Let's pit one witness against the other.
Have you been to a trial?
Most witnesses are inconsistent. They take it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness.
Can you just address the arguments that Alessi made?
They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welcher these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination.
He didn't rely on the analysis of Trooper Paul, but it doesn't mean he didn't rely on the information from Trooper Paul.
Or undetermined determination by Dr. Scorbello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor, it's not a tether, it's not an adoption, it's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions, efforts, what Zach Clark did.
Well, no, not if he didn't write the report. The photo wasn't
a report. Not an opinion, not an analysis. It has.
But he relied on things from Trooper Paul's report.
Nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out,
used the information,
conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what
do all the
was
work
part
himself.
of his opinion and what was not. And
he relied on.
Was not part of his opinion.
It was.
They turned to the Google map.
It was though. There was information that was part of his analysis, like what the mileage of the car was. Pretty relevant to this whole situation.
Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at
I'm not persuaded by the Google stuff either.
It's different.
That's fine.
Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case. Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Scortibello of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions to try to do a credibility eval is a core preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red? It's the absolute same analysis. It just has a lot of icing on it.
Very briefly, bring the jury. Start getting the jury ready, please.
Bring the jury.
Your
Very
Honor,
briefly.
with regard to Trooper Paul, Mr. Brennan did not address 80% of the slides
That's
that I
not
addressed
wrong.
that showed the
That's
basis.
not wrong at all.
When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items. But even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it. It's the fact that that's the odometer reading they're using. Next point with regard to case law. Mr. Brennan presents none to go against the common sense law that has been there for years. The other thing, Your Honor, is with regard to Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here.
Right.
And because of that,
He used the work of Trooper Paul, though not the analysis, but he still used the underlying work.
we get the right to cross-examine it. Last point. This is not about credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher,
Did you
you
use this
have brought
shit?
up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation.
It is.
But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that
he's
he
sure gonna.
needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go
but
after
he's gonna
that
do
because
that.
it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law. Thank you.
It's the foundational information.
I disagree with you, Mr. Alessi. I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scortibello.
Wow.
So that's my ruling. Let's bring the jury in. Well, come over here because they're on their way.
And the court ruled immediately that there was no allowance for a line of questioning regarding Trooper Paul and no allowance for a line of questioning regarding Dr. Scortibello. I think that it is fair game to cross-examine the Commonwealth's new accident reconstruction expert about what they relied on from the previous accident reconstruction expert. Does that mean they get into all of the opinions from the previous accident reconstruction expert? Not necessarily. But can you ask about the information that was used? You should be able to. But if the defense wants to call Trooper Paul, then the defense is going to have to call Trooper Paul under the court's order. With regard to Dr. Scortibello, I think it's a bit of a closer question depending on what the defense wants to ask. The defense can ask about Dr. Scortibello's findings, but not ultimate opinion, because it's just hearsay as to this witness because that wasn't relied on. They did rely on the autopsy report, but whether or not the ME says, oh yes, this is common in accidents or not, isn't what was relied upon by this expert. So I think it's a closer call for me with the ME than it is for Trooper Paul. Now, what the full line of questioning they wanted to get into was about the key cycles. I don't know if they can get into the full line of questioning about how Trooper Paul fixed the key cycles, but they can ask about, you used these things from Trooper Paul. There has to be a line between it. So I don't know the entire line of questioning they wanted to ask because that was done at sidebar. But she has cut off the entire line of questioning, it seems. Some of that should have been allowed in, not all of it. However, if the defense chooses to call Trooper Paul, we have heard that Welcher will be back as a rebuttal witness, and then it would be asked about at that point in time. So that can happen. So let's continue on past the jury walking in. I didn't hear yous this morning either. There might have been, but we didn't hear them. So, well, now that the court has ruled, they're going to be bringing the jury back in for the rest of cross-examination. And we will see where they get by the end of today with a 20-minute break. Oh boy.
You may be seated.
All right, the jury is in. Let's continue on.
Morning, members.
Those
I do
decisions,
appreciate you waiting.
I saw lots of questions. Those decisions are soundly within the discretion of the judge. Squarely within the discretion of the judge. I don't have to agree with them, but when it comes to lines of cross-examination, especially when we get to lines of cross-examination that deal with or witnesses that haven't testified and their opinions that weren't relied on, it is within the discretion of the court. And on voir dire, Welcher said he did not rely on the opinions of Trooper Paul. I think he relied on the underlying information. I agree with y'all. But he's not going to be allowed, according to the court, to ask about Trooper Paul's opinions. So, even if it came up on appeal, it would probably be one of those things that's within the discretion of the court because they were allowed, well, we'll see if they're allowed to ask where that information came from. But the defense can call Trooper Paul. It does not forestall the defense from calling Trooper Paul. It doesn't. Does the defense necessarily want to do that? Maybe not. But it doesn't forestall that. So we'll see. I think there's stuff in there that should have been asked about. The ultimate question with regard to the cause of death being undetermined and stuff, I think that's a little closer call. That doesn't surprise me. Some of the Trooper Paul stuff, I think they should have been allowed to ask.
We were doing work in here, but we appreciate your patience.
Because
I do have
he
to ask
used the
you
underlying
two
information.
questions. Were you all
but he didn't
able
use the
to follow
opinions.
the instructions and refrain
He was
from
told not to use the
discussing
opinions.
this with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to
Survive
see
2025 said, why wouldn't they want to call Proctor? Well, we were talking about Trooper Paul.
Everyone said no.
I think they'd want to call Proctor.
Dr. Welcher back there?
But as to Trooper Paul,
Go to the podium.
it can be a bag of worms you might not want to open.
It doesn't look like it's turned on at all.
Oh, okay.
There might not be enough payoff.
And smart watches.
The defense immediately asked about this witness's computer being up at the podium. I've never seen an expert have this many issues with reading all their shit on the stand even after they're admonished not to. I don't like it at all. Michelle in the chat said, EDB, I think the judge should have to cite case law that supports her ruling. It's within the discretion of the court
Dr. Welcher,
based on the rules of evidence.
turn on your computer yet.
So it's within the discretion of the court. She doesn't need to cite case law for that. And most judges
Your Honor, if I
don't
could,
on
smart
evidentiary
watches that
rulings.
are receiving text messages during his.
He's going to say it again right in front of the jury. Alessi is not daunted.
And Dr. Welcher, we're going to ask you to not turn on your computer yet.
Okey-dokey.
Thank you.
And Your Honor, if I could, smart watches that are receiving text messages during his direct, if we can make sure that that does not occur.
I did get my email. I know what's on.
Okay, or just don't look at your watch.
Okay.
I look at my email on my watch. Alessi's just like, sir, stop looking at everything. And for all of you in the chat that are like, this would be miserable for me because if my watch beeps or bops, I'm going to look at it. He could put it in airplane mode. He has options. He chose to be here. But it is really like a junior high school teacher having to say, put away your devices. Though where my youngest goes to junior high, they're not allowed to have their phones in the building. They all get checked into the office. But it's wild the amount that he's just like beep booping away on his devices. And I was really annoyed with Dr. Hughes's freaking post-it notes. This is wild. Okay.
Thank you, Your Honor. Morning, Dr. Welcher.
Good morning.
Do you know whether there was glass found on the bumper of Miss Reed's Lexus SUV?
Right into it.
My understanding there was, yes.
Did you reach a conclusion on whether the glass on the bumper came from the drinking
Katie,
glass that you
I see your
assert
question. I'm
Mr.
gonna save it for a little
O'Keefe
bit.
was holding at the time of
Cross
the alleged
resumes.
impact?
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
So
You don't know they're not
as
the
you sit
same.
here today, you have no basis to conclude that the glass on the bumper came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So can
if
I-
you can just...
Alessi's a new bitch this morning, and I'm here for it. Alessi's just like, Overnight, I sat down with Yannetti and Jackson, and we had a little combo. I'm speculating what Alessi was doing. I'm not saying I did. I don't talk to the lawyers. You can see how internet can internet, but I imagine Alessi sat down with Jackson and Yannetti and had a little conversation about what are we gonna do with this witness. And today is a bright new day of you don't get to do whatever the fuck you want on the stand. I'm interested to see how long that lasts, but answer my question. Answer my question, because this expert made a lot of assumptions. And with an expert that is dealing with accident reconstructions, you want less assumptions. You want this fact, this fact, this fact, this fact. Put those together, conclusion. You do not want fact, assumption, assumption, assumption. You should not be bridging the gap this much. And that, I think, is where Alessi's going with this. I backed it up a little because Alessi was getting into the not today.
Came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So
if you can just answer my question.
I'm
If
trying
I
to.
need to rephrase it, I will. I'll ask it a different way.
Please.
He needs shorter questions.
You have no basis as you sit here today to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene. So I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
Shorter questions. I want to know if he saw
You
the reports that showed that those aren't the same.
had depictions in your test with Mr. O'Keefe holding a glass, correct?
Correct.
My question is, you have no evidence
Short questions.
to show
peace.
at all other than, and I'm talking evidence, testing information. You're saying you have no evidence that shows that the glass on the bumper is not the same glass as you showed on your slides as being found supposedly at the scene. You have no test evidence that that's the same glass, do you?
So again, the one I have at my testing obviously was not the same glass. We have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was. We have
Okay.
glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation between those two.
So, you said you reviewed the reports and testimonies of various Commonwealth representatives, correct? That's in your report.
Correct. In the initial.
In the initial, right, correct. And some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
Well, if you
And as you
reviewed
sit
them,
here today, it's your testimony. You don't know whether in any of the reports of the Massachusetts State Police there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the tail light fragments back together, they were able to deduce that the fragments were from the tail light. I don't think they attempted to do that with the glass.
oh, they did. They did.
Assume
They
that there
100%
has been
did.
testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from.
Right.
But we still have a whole bunch of other elements. So I don't think it would affect the end results.
So, would it
I
have
don't
any
think-
part in your analysis
Yeah,
with my
some.
assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes. I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that
It's a great line of questioning. Isn't this one of the assumptions you made? You saw a glass at the scene, you saw glass on the bumper, you held the glass like this, you assumed that that broken glass ended up on the bumper. But what if it didn't? Did you even consider that? It's a good question because as you start, again, House of Cards, as you start pulling out the foundational pieces, and the foundation of a lot of this is assumption, as you start pulling out those pieces, it starts to crumble the foundation of the opinion. Much stronger than fighting over fucking physics, I think.
the test results show there's no connection, meaning the glass on the bumper is different from the glass in the snow, wouldn't that be contrary to your theory of what happened in some way?
It depends on when the glass was actually broken. The glass was in his hand, at least that's the testimonial
Karen Reed
evidence I've
said.
seen. So it depends on whether it's broken
Testimony evidence from the first proceeding, but it's also in Karen Reed's interview.
from contact with the rear of the vehicle or broken with contact on the ground.
Assume that the glass on the bumper is not the glass that was found in the snowbank. Doesn't that, at least in part, contradict your hypothesis as to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview?
So if you recall all my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
But you didn't seek that information, did you, sir, in your analysis to determine where the glass came from?
Well, of course I did. I read the reports about it.
But you
Not all
sit
of
here
them.
and you say you don't know the answer. There's steps you could have taken to get that answer quite easily. Couldn't you have, sir?
Not me. That's a material science expert.
And they did
You've
that.
been communicating with Lieutenant Tully, haven't you?
Correct.
They didn't give you the scientific reports because they did
You couldn't
that.
have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just, has there been testing,
Don't
and
you
if
have
so,
that
what's the
report?
results?
Yeah, don't you have that report?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
Well, the
Let's
jury
turn
knows
to
it.
another topic. Laser scans.
Okay,
Part
lasers
of your
are cool.
analysis
I'm here
involved
for
conducting
lasers.
laser scans of portions of One Meadows Avenue.
The jury knows. This is where I can highlight well the puzzle pieces of putting together a trial. Because this is not clear to this witness, but it's clearer to the jury and us watching because, well, there was that real big chart from the cross-examination that Jackson did. And the chart showed where things matched really simply. So did this go to here? Did this go to here? Did this go to here? No. So the jury has that information clearly in their mind. Because the way the prosecution presented the evidence about the glass and the spectrometer and the rest of it was really hard to follow. But when the defense came in and was like, this chart, broken glass A, glass on bumper B, not a match, the jury can be like, well, we know it wasn't inconclusive. They didn't match. They weren't the same. That's not inconclusive. That's not a match. That's different. And they know that and he doesn't. All right, so let's talk about lasers as we're moving on. But that's where those building blocks of a trial are really important. That's where the planning is important. Because going through all the tedious steps to get that chart into evidence builds for this moment when it's like, no, the jury can sit there and be like, it's not inconclusive. I know that. We already saw it. You don't have all the information, expert. Weird.
The house of Mr. O'Keefe, correct?
Correct.
Those laser scans were used, at least in part, to answer the question of whether the collision between Miss Reed's SUV and Mr. O'Keefe's Chevy Traverse at One Meadows at approximately 5:07 a.m. on January 29, 2022, caused the right rear taillight of the Lexus to break, correct?
Correct.
And in that analysis, inches literally matter, correct?
You want to get it as accurate as possible.
And the reason why inches matter is because, and we're going to get to this, you try, and you did it in your slide presentation on direct, you tried to see whether the Lexus lined up with the Traverse such that there could be a break of the taillight. That was part of your analysis, correct?
So the main part of the photogrammetry
too.
was to determine the speeds and the angles and the degree of overlap on the vehicles. And then we also looked at the damage from the video, or actually it's just where the snow was knocked off the rear of the Chevy Traverse, and document the height of that.
You said the main part. I don't want to engage in semantics. I want to go to my question of, isn't part of the laser scan analysis to determine whether or not those two vehicles align sufficiently such that the Lexus could break, the taillight of the Lexus could break coming into contact with the Chevy Traverse? Wasn't that part of your analysis, at least in part?
Yes.
Okay. And in that analysis, inches literally matter, correct?
It can, depending on which way you're going inches.
So the ring camera at One Meadows, you're familiar with that ring camera, right? At
Correct.
One Meadows? That ring camera at One Meadows was used as part of the laser scan process that you and your firm Aperture performed at One Meadows on October 2nd, 2024. Do I have the date correct?
I believe so, but like the videos were not literally used during the laser scans. We took the laser scans, the video, combined them together in a process called photogrammetry.
Okay, let's get this down to the fundamentals. You used, and that was my question, Your Honor, if we could publish the exhibit.
Unless he tried
with regard to
nicing the
ring
witness
camera.
yesterday and being polite, and now it is just a answer my questions or we're never going to finish. Like we're never going to be done. Ever.
Dr. Welcher, you recognize that ring camera as being at One Meadows. You discussed it, as a matter of fact, on your direct testimony, correct?
Yes.
Now, that ring camera was
My coffee's gone so
utilized
fast.
as part of your laser scan process, correct? It was used.
So you're confusing laser scan and photogrammetry.
Oh my God.
The video, the laser scanners are
That's
together
fair, but still.
used in the photogrammetry. The camera and the laser scans are not used necessarily with each other.
And Alessi has to be precise with his questions because of the way this witness responds.
Was that ring camera used for any part of your work?
Absolutely, the photogrammetry.
Right.
I just need to be able to finish my question, sir. Was that...
Sorry.
The thing is, we know what Alessi means, but this witness is going to go with the most literal possible interpretation and just draw it out. So Alessi has to be precise. He didn't use the ring camera to laser scan the driveway. He overlaid the ring camera video on the laser scan to then determine what was done. And every scientific witness is going to do that thing. But I imagine it's going to matter where the ring camera is placed, right?
ring camera used for any part of your work at One Meadows on October 2nd, 2024?
Yes.
And it was used for what purpose?
In the photogrammetric process, to establish the position and dimensions of various things in the video. So then we could go back and overlay the vehicles and track the tracks in the snow, as well as look at the damage to the vehicles.
Right. So this was used to, as a
line.
basis, not the only one, to establish dimensions of the other work that was done in analysis at One Meadows, correct?
Correct.
You can take that down, Mr. Wope. You know that the ring camera at One Meadows, in existence when Aperture did the work on October 2nd, 2024, was different than the ring camera that was in existence on January 29th of 2022, the date where you went through to see if those two vehicles align. Is that correct? The cameras are different.
That is correct.
And you know that the cameras are different, and you knew that as part of your analysis, correct?
Correct.
Did you document the differences between the two cameras as part of any work performed at One Meadows?
Yes.
And did you measure any differences there might have been between the location of the newer ring camera from the older one that was in existence on January 29th of 2022?
No. What we did is use the current ring camera in conjunction with the old ring camera, and with the laser scans, we're able to, again, map the points onto them. That's why I showed you the report from the photogrammetry software that reported our error.
Sir, my question was just measurement, not your process.
Oh.
Did you measure the
Simple
difference
question, man.
I don't believe so.
between where the old camera was and where the new camera was?
No, it was angled slightly more to the right, though.
How would you know that if you were not retained on January 29th of 2022? How would you
Looking at
know
the
where the
video and the
original
photos?
angles were?
Because when you look at the first camera, the one on January 22nd, it's here. The new one is slightly over to the right.
That's an eyeball approximation analysis. That's not a measurement, correct?
Well, I don't know that we actually measured it, but we accounted for it and corrected for it. But you can see, for example, what the original one shows, for example, to the left-hand side, compared to what the new one shows to the left-hand side, and it's angled more to the right.
Sir, you have experience with Ring cameras, correct?
I do.
And I think a lot of members of the public have experience with Ring cameras. You can move just the camera portion ever so slightly and change significantly the angle of the camera, can't you, what it captures? Just a small turn.
Potentially.
Right. Even a millimeter turn can make a change.
But they
a 2
use the
millimeter,
video,
a 1
though.
inch can make a significant change with regard to what the camera captures, correct?
Could, sure.
So,
He said he accounted for it.
did you measure whether the newer camera that was present on October 2nd, 2024 was installed to the left? And I'm talking measure. To the right, to the top, or the bottom relative to the camera that was there on January 29th of 2022?
So we solved for the camera
I'm
position.
asking if you measured, sir.
Oh, no, we didn't measure.
So let's talk about some other differences with regard to cameras and Ring cameras. Different Ring cameras can have different levels of distortion, correct?
Potentially.
Cameras, well, are you saying that all Ring cameras have the same level of distortion?
No, but again, they're
He said
mass
potentially.
produced, so you could have some that have the same exact distortion. You could have some that have different.
And you don't know the comparative distortion between what I'm just going to now refer to as the old Ring camera that was there January 29, 2022, and the camera that you saw on October 2024, which I'll refer to the new camera. You don't know the difference
What
in
are
the
you looking
distortion
at?
between those cameras as you sit here today, do you?
So we know enough information that if the distortions had been different, our errors would have been too high. And so the fact that our errors are within acceptable, are what's called an RMS error,
What errors?
we know that the distortions are similar enough to give us accurate measurements.
Sir, that is speculation. That
It's
is
not-
not data. That is not a measurement. You
let's see
didn't
that's
measure
argument.
the distortion, sir, did you? If the cameras, you didn't have the old camera to do it.
We didn't, but we had images from the old camera. And then when we get images from the new camera and solve those camera properties and then overlay data from the old images to the new images with the point clouds, if that distortion is too great,
Can we get back to the
we
errors?
will have too high of errors in our project, which is why I showed the error report from the photogrammetry process to show that we have checked for that and documented that our errors are an
I
acceptable
don't even
range
remember that.
so that we have confidence in our results.
You do not have information from the manufacturer of Ring. You didn't present it, and you don't have it as to what is the acceptable level of distortion for the analysis that you did, do you, sir?
The
You have
photogrammetry,
that from Ring.
and I don't have it for Ring, but I
Thank
don't need
you.
it from Ring.
So now let's go to, if cameras have different levels of distortion,
Right.
that would change the analysis in reconciling the difference between their angles. That's a pretty straightforward proposition, sir, wouldn't it?
So it depends on how much difference it is, but we have accounted
It
for that.
depends. Okay.
With
How did you account for the difference if you don't know what the difference is,
Which model of the
though?
Ring camera was present at One Meadows on January 29, 2022? Which model?
I don't know. I'd have to go look through the data.
Do you believe I'm not going to take up the time to have you look, but do you really believe you've got the model of the Ring camera that was in existence on January 29th of 2022?
I don't know. I
You
need to
didn't
look through the
present it
report.
in your direct testimony, did you, sir?
I did not.
So do
He doesn't know
you
if it's in there or
have
not.
the model of the Ring
Which is the
camera that
point.
was present at One Meadows on October 2nd, 2024?
No.
So you don't have even the model for either one of them.
Nope. But we have videos from both of them and scans of the scene.
So now let's talk about another aspect of Ring cameras. They have mechanisms, as I was talking about earlier, that allow the user to adjust the camera angle, correct?
Correct.
And do you know whether there was a difference in the camera angle between the two cameras?
Yes, as we already discussed, there was a slight difference in the
But
angles.
you don't have a measurement of that, right, sir?
Correct.
Okay.
But we accounted for it.
So
How did you account for it if you don't know what it is? How do you account for something you don't know what it is?
wouldn't a difference in models of Ring cameras
He's like,
be
we accounted for it.
relevant at all to your analysis of trying to reconcile any differences between them?
So if you have video from both of them and you have laser scans with three-dimensional geometry of the scene, you can go in and it's called a reverse camera analysis and solve for
I
the
wasn't
distortion
sure where that was
properties.
going.
The scans give you the real world dimensions. So once you know the real world dimensions, you can then go in, you can go in and then solve for the camera lens properties based upon the real world distortions. So for example, if there's a little bit of bending at the end, the laser scan data will show that, and you can correct for that knowing information about the laser scanner.
I'll ask
the
the
laser
question.
scan data.
I'm sorry, I thought you finished, sir. I'm going to ask the question again because it's a narrow question. Wouldn't knowing the difference in the models be relevant? That's all I'm asking. Wouldn't it be relevant to your analysis of reconciling the differences to them? Wouldn't
No.
it be relevant?
No.
So you think the different models are irrelevant to any
I mean, they might well be
process
if the
you
photos overlay or the
occasioned it?
videos overlay.
It's irrelevant.
So the analysis of the video itself is more important than the models?
I'm not asking if it's more important. I'm just asking, would it be relevant?
I mean, if they overlay
No, I don't believe it'd be
accurately,
relevant.
Now let's go to another
model might
aspect
not matter.
of the cameras. Are key parameters in a camera that the software needs to know focal length?
It is.
Is imaging size something that is an important parameter in a camera?
Yes.
Are sampling characteristics an important parameter in cameras?
Can be.
Is the principal point, you understand that concept, sir? Is that an important parameter in a camera?
Define how you're using principal point.
Sure. A principal point of an image is the point where a camera's direct line of sight, called, as you may know, the optical axis, intersects the image. Does that
Gotcha,
sound
yes.
familiar? Mm-hmm. So isn't that the image's mathematical center, the principal point?
More or less, yes.
And for high accuracy photogrammetric work, it's important to know if the lens mounted centered over the image
unless he's back
sensor
to, I'm smarter than
due to
you.
the small manufacturing variances, correct?
Could be important.
Yes, I
And
wore my absolutely
if
not
the
shirt
principal
today.
point is the center of the image.
Okay.
That's relevant. So doesn't that affect the mathematical calculation of the light ray geometry?
It could.
So the variance in manufacturing between cameras is a known issue. Do you agree?
I do.
There's small manufacturing variances that affect one of the key components of the fundamental parameters of the camera, namely the principal point, right?
Correct.
Did you perform the camera calibration of the camera in place in October of 2024?
Yes. So within photogrammetry, we calibrated the photogrammetric analysis to the camera.
How?
Did you address the principal point in that calibration? Do you have documentation that you addressed that important factor, the principal point?
So the checking of the RMS error in the software takes into account, sums up all the potential errors in the measurements, which would include that.
So the answer is the software did it.
Sir, you know the importance of all of these topics because the output of all the work Aperture did at One Meadows, almost all of it, springs from that camera, correct?
It starts there.
Okay, it starts there. And if the starting point is wrong, then where you go from the starting point is going to be at least potentially wrong, correct?
Potentially.
Would you agree that Ring cameras have a swiveling mechanism so that the user can adjust the camera angle?
It depends
Some
on
do.
which Ring camera.
You know whether the camera that was in existence on January 29, 2022 had a swiveling mechanism?
I believe it did.
Believe? Do you know?
I do not know for a fact, but
you-
those style of Ring cameras on the surveillance have adjustability that includes angle.
But you don't know whether the camera that was there, the specific camera on January 29, 2022, had a swiveling mechanism or not, correct?
Correct.
And do you know whether the camera
That was
that
a
you saw
straightforward
in
answer.
October of 2024 had a swiveling mechanism on it?
It did.
And where did you document the fact that it had a swiveling mechanism?
I think we have photos of the camera.
Did you document it in writing, and did you document the tolerance of the swiveling mechanism?
No.
Let's go to, and again, all of the camera, this camera that you used is the starting point for your laser scan and photogrammetry process, correct?
I want the conversation about
Correct.
lasers to be
All right.
cooler.
Let's go to another topic.
I know it matters very much to Alessi
On your
because
direct testimony, as I recall, you stated
the damage to Karen Reed's Lexus is critical in this case. So this expert and attacking this expert and the underlying foundation of, hey, Karen Reed's vehicle could not have been damaged by bumping into John O'Keefe's vehicle is critical. So they are chipping away at the foundation of that opinion. However, it is very in the weeds, but it is foundation that is needed. Like I said with the chart from Jackson earlier, it is foundation that is needed for later argument. They need to pull at that foundation and ask this witness about it. So you didn't do this, you didn't do this, you didn't do this, you didn't do this. So if the foundations of your data are incomplete or are inaccurate, then how do we have an accurate result? However, it is also very in the weeds.
essentially from various information that you lined up in the video, and we're talking about the lining up of the Lexus with the Traverse. And this is at One Meadows. And so, as I understand what you did, sir, is you took what are called point clouds, 3D images, created them for the Lexus. You took created 3D images, synonym point clouds, of the Traverse, and then you attempted to line them up to determine, among other things, whether they would align sufficient so that the Lexus could line up and potentially hit the Traverse such that the tail light of the Lexus could be broken. Was that at least part of your analysis?
That was part. There was more.
So, you showed a slide, a few slides, and with Your Honor's permission, what I'd like to do is to start with slide 90.
All right, do you have any problem with Dr. Welcher keeping
Slides.
printed copy that he was using?
I have no problem with the printed copy, Your Honor.
Yeah, don't let the man back on his
I'm
tech.
sorry, what slide again?
90.
Your Honor, my printed copy tiny.
Can you see the,
Yes. Yeah.
I appreciate that when he's like, but my printed copy's too small for me to read. She's
Is
like,
that
okay, but can you see the
slide
screen? Look at the
that's
screen
part
then.
of your presentation.
She's not letting
Depict a
him.
view from the top.
turn that computer
of
back on.
The Lexus on the right.
I don't think I've ever seen an expert witness have like a timeout. Like he's on a full like iPad timeout. Like no more screen time for you, sir. None at all.
In the Chevy Traverse on the left.
Correct.
And is that depicting contact between the two vehicles?
It is?
Now let's zero in a closer look, and that is a contact point. Am I correct?
Correct? I mean, there's multiple points. There's more than one.
Multiple points, but it shows more clearly the contact
Correct.
between the two vehicles. Now if we could the next,
Where are we going next? Back to
and
the
that
3D
is number
scans.
91, Mr. Wolf. So, Your Honor, 91. I think these are just going to go in order for a
That'd be
few,
great.
and I'll keep announcing them. So, this is 91, same vehicles, just a different viewpoint. Is that correct, Dr. Welcher?
Correct. This and the next
I
slide.
just want to stay
I know.
with this one. I just
Hold on a
asked the
second.
question, does it show the contact?
Right. So go ahead and answer now.
Witness, let questioner finish asking questions.
This slide and all the other slides, we're trying to show the angle of contact, but because it's two-dimensional image, you're losing some perspective. For example, here you're seeing the chrome piece on Mr. O'Keefe's Chevrolet,
It's
which
like
is on the right.
The angles can
You're
matter
seeing
for perspective.
Obviously,
I think that's
behind
the
where the
point
Lexus is.
of this line of questioning.
We were trying to show it at a whole bunch of different angles to try and illustrate the degree of closeness or lack thereof.
I think the
All right.
top down is
So,
the most helpful.
Is it correct that on your direct examination, you said in sum and substance, we looked at the degree of overlap, and there's only about a 2 to 3 millimeters of overlap between the vehicles? Is that what you recall saying on direct?
That is correct.
And
look,
that you
millimeters.
stated that supposed 2
Even
to 3
smaller than
millimeters
inches.
of overlap was insufficient to cause the tail light of the Lexus to contact the rear of the Chevrolet. Do you
It's a
recall
good
saying
line of
that?
questioning.
That's correct.
Now, I would like you to look at that. This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind.
I told you we needed the absolutely not shirt today. Oh, it is absolutely not. So confident. This is a good line of questioning for Alessi. I know we had to get into the weeds to get there, but this is a good line of questioning. Because if all of you, there are what, 40,000 of you in the chat, are all of you sitting there looking at this going, the fuck? Because the defense wants the jury to be sitting there looking at this photo and going, what do you mean it doesn't show contact? That's what these questions are for. For the jury in their brains to go, what? How? That's the point.
Behind the area, keep in mind the angle, the Lexus is angled off to the left. So the area that you see here is actually, in this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it, you see stuff in the background. So and again, this is why in the computer, we overlaid them, looked at the measurements, in the computer where you don't have this, we have the three-dimensional measurements, and it does not hit.
Where did you show in your slide presentation what you just said that it doesn't show in overlap?
So
Where?
it shows a contact. It definitely contacted, I'm sorry, Mr. Reporter.
You just said it
down
absolutely
below
doesn't
here.
show contact.
It does not show a contact here. So to answer your question, all the next slides were our attempt to do that. So all the next slides is your answer.
We're going to go to those next slides. So just to be clear, you're saying that depiction does not show any contact between the taillight of the Lexus and the Chevy Traverse.
So the upper taillight, just to be clear, because the lower taillight is much closer.
Well, it's not only much closer, it's in contact, isn't it, sir?
It's very close. It's probably within an inch of being in contact.
Oh, so you state that even the lower part of the taillight is not making contact?
So, if again, maybe there's a photo we could show or a scan.
That's not
is
how
on
this
the rear of
works.
the vehicle, and it contacts on the corner, which is just around, so maybe like an inch or so in front of it on the corner.
So like an
I'm
inch
just
matters?
going with what you presented in your slide
Well, let's
presentation.
go to the next slides, and then
Sir,
maybe
I
we'll see
will
it.
determine which slides we go to on my question.
I'm just open
So
to
now
answer your
let's
question.
go to, Mr. Wolf, the next slide.
I'm in charge now, sir. Alessi has stepped into, I'm in charge now, bitch. Let's go. Oh, cross-examination, man. Alessi was like, nope, not today. We have a half day. We've got to get through this cross, and we are not doing it. We are not doing it. We are not doing this. I'll determine what slides we go to. You're not directing this presentation today. Totally different approach to cross on day 2. It was needed. We still need shorter questions, though. We still need shorter questions. Just real bite-sized questions.
There we go.
In your presentation, my question
Boy, oh
is
boy.
zeroing in. Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light. This structure, and again, remember I said the Chevy kind of curves in as it goes up a little bit?
Let's
That taillight does not look like that in the photos. I get that it looks like that in the 3D models.
go to the next slide.
Also, the Chevy logo doesn't look like that in the photos. I get that it looks like that in the 3D model, and that's the thing. And for all of you asking, those photos look like shit. They're not photos. They are 3D scans. So yes, they do look like shit. Ah! Well played, Alessi. Hey, this taillight isn't all wibbly wobbly. Why is the other one all wibbly wobbly? That doesn't look wibbly wobbly at all. Look at that. It's kind of a flat
That's Exhibit 41?
edge. It's not photoshopped. It is 3D scanner. And then put into the computer. So it is a scan of the car, which makes them look a little different.
Mr. Alessi, is this exhibit number 41 or is this from the PowerPoint? Because,
Slide 41.
The court's like, because I don't even know
okay.
what we're doing. Fair enough.
Yes.
So I'm putting this up because I want to show an actual photograph of that tail light, and I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? You see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back to the depiction we were just looking at, and that
Wibbly
depiction
wobbly.
doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But-
can't see them.
Hold on a second. I wasn't finished.
Oh,
But
Sir.
they are 100% there.
Talk over him, Alessi. Me talking over both of them. I wasn't finished. Alessi's like, sir. Keep going, Alessi.
The vehicle, you can't see them in this image.
Correct. You
But-
can't see them.
Hold on a second. I wasn't finished. But
Sir.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you? The jutting out that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see on the side of the tail light because it's on the side I can't see. It's being blocked.
Sir, my question is simple. You cannot see the jutting out of the tail light in this depiction, can you?
Correct.
Okay, now let's go on to the next question in this topic. You could have easily solved what you consider to be the issues you had with trying to show it lining up, couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what you're referring to.
You had 3D images, correct?
I did.
You could have shown and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans, on top of each vehicle. So we took the, we took the vehicles.
Don't interrupt.
Hold on.
Your Honor, he keeps referencing my hand and saying I'm doing something when I'm not, and I think that's distracting to the jury. I'm not interrupting him.
Hold on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing something.
Mr. Alessi, please.
All right.
Go ahead, finish.
At this point, Alessi should ask to approach and tell the court to instruct the witness to answer the question and stop. Alessi's pissed. And the witness, we're in a full battle for who's in control of the cross. And we can't see how Alessi is standing. But if Alessi is standing there and he's going, no, let me finish. It's a power struggle. And Alessi's like, I'm not interrupting. The power struggle in cross is real. And Alessi is pissed. But Alessi can't lose his cool if he is going to maintain control of the cross-examination. If he loses his cool, the witness is going to be like, ding, ding, ding.
Your Honor, he keeps saying that I'm doing something.
Mr. Alessi, please.
All right.
Go ahead, finish the answer, Dr. Welcher.
Again, in the photogrammetric analysis, I showed the video. I showed how we overlaid the point cloud on top of the video. That proves that the way we solved it, correct camera characteristics, matches. Otherwise, that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the scene into the photogrammetric analysis. We overlaid all that stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was
they are
no
gonna
contact,
keep fighting over
or
who's in control
not
of these
sufficient
questions.
contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir, I get to ask the questions, and you are to answer them subject to the judge's ruling. So my question is, couldn't you have created a graphic that would have better shown the issue that you are creating or talking about today? That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do a top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in two-dimensional images, you lose one dimension depending on which way you're looking. That's why I showed it from all these different angles to try and show exactly what you're saying. We had graphics to do that.
3D images allow you to show perspectives for 360 degrees, correct?
So where
Is
are
that
those?
correct?
That is correct.
So, none of what you presented in your slideshow shows the contact points from 360 degrees, does it?
I don't understand your question. Are you asking if I showed it at every single, I went through 360 slides that showed it at every single degree?
Sir, let's move on. I think I've made the point.
So I'm going to strike the comment,
Okay.
Mr. List.
Dr. Welcher,
Which is
let's
rare for
go
Alessi.
to
He
the
doesn't
next topic.
tend to quip very often. And he
And keep
gave
with
up,
these two
I think, the
depictions.
point because we're never going to get a clear answer with this witness. But the witness is trying to win the point so that Alessi moves on. It's not unintentional. He's like, great, we'll do this all day long. And Alessi is trying to nail down the points that they want to ask their experts about, which is hard to do when this witness is just like, he's just going to skip, skip over the point. Oh, it's going to be exhausting.
Are these two images point clouds or 3D images? Are these two?
Those are one and the same thing. Yes.
I would use them as synonym. Which term of the two do you want to use? Point cloud or 3D images?
Both are fine. It's a 3D image composed of points.
So let's just call them 3D images.
Great.
We can do this more quickly. The Lexus and the Chevy Traverse that are depicted there are both 3D images of those vehicles, correct?
Correct.
And Aperture created the 3D images, correct?
Correct.
Sir, did you do these scans and did you personally create these images?
No, one of the assistants at Aperture did.
So you're speaking about what somebody else did at Aperture, correct?
They were doing it at my direction. And for example, the Lexus scan.
So yes.
I showed the photographs. You can see the gentleman that works at Aperture, Mike Morelli,
So then, yes.
was scanning them for me while I was doing the rest of the inspection. And then the hand scanning of the rear tail light was done by another engineer. I was out there with him doing it, taking measurements. And then same
yes.
thing with the Chevy Traverse.
My question is,
So yes.
you didn't do the creation of these 3D images, did you?
The individual images, no.
All right, so let's go to these individual images. These are 3D images, is that your testimony?
Yes.
Let's look at the tail light.
Okay.
That's not a 3D image, that's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that that tail light.
Now I want to
is a
see it.
3D
Can we
image.
see it?
That absolutely is a 3D image. The way you can tell is when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse.
Lasers don't like shiny objects.
Let's, Mr. Woke, zero in on the content, yeah. There's grain on that tail light, in the tail light. Mm-hmm. That's a 3D image of the tail light, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That tail light is a 3D image, and one of the ways you can tell is because it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No,
Okay.
thank you. I would like to
He's
go
like,
to the
no.
bumper. Do you see any the predominance of any grainy image on the bumper?
There's a little bit. So, for example, when you get near edges, it has a hard time with edges.
I'm
So
sorry,
you-
the bumper cover.
right.
See the bumper cover up above?
This whole thing is the bumper cover. That's the step pad. That's the rear body panel or the rear deck lid.
I'm talking about the step pad, sir. Just the step pad of the bumper?
Are you asking about just from here to here?
Correct. The bumper step
Can we
pad.
zoom in on it?
Pardon me?
Can we zoom in on it?
Sure. Do you see any?
Yeah, I see graininess.
Let's go over to...
Right in here. You can see it all through here. You see it through here.
Well, I'm talking about the step pad, not the entire bumper. I'm just talking about the step pad.
Right. So you're zooming in on the bumper.
Right.
The step pad is this structure up here.
We're going to move up. It just takes a while. So your testimony is that is a...
Can you zoom in more?
That's you would like it zoomed in?
Yes, sir.
Sure. Your testimony is that that is a 3D image, not a Photoshopped step bumper cover. Is that correct?
So we have mapped the color over the 3D scans.
Mapped
we used
the color
two
over the
separate
3D
scanners.
scans?
If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the
What?
bumper cover, not the tail light.
Okay, I'm explaining the process.
I'm just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to
Did
do.
you do it?
I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, and this. Use
So
the
you
hand
don't know.
scanner, go scan the light. I need to put this back in
So you
because it
don't
was
know.
missing when we got to it. So no,
Okay, but how did you add in a taillight? Did you splice it from the other Lexus? Because you scanned it with the taillight missing, so how did you add it back in?
no, I'm not punching the keys.
Okay, so
Okay. Come over, please.
And to sidebar. Right to sidebar. I think we're getting to a very interesting point of we added it back in. All right, let's skip that
hydraulic
sidebar
system.
and get back into questions. I skipped a little too fast.
With
There we go.
regard to, no, we don't need him back up, Mr. Wolf.
Zoom past
Isn't
sidebar.
it correct that 3D images allow for proper and most accurate measurements as opposed to 2D images? Is that a correct general statement?
I mean, generally, yeah.
Okay, that's my question. So let's go to the next topic. Let's talk about hydraulics on the Lexus SUV. What type of hydraulic system does the Lexus SUV have?
Everybody wanted to know about this yesterday. Chat, all of you asked, hey, what about the hydraulic system? What about the Lexus changing its own height? And lo and behold, here we are.
So it has a mechanism, I believe it's actually pneumatic. It's air-based system that raises it up and down.
Do you know what the name of that system is, sir?
No, not off the top of my head.
Do you know how it works
I do.
specifically?
Well, I mean, I know generally that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system
Doesn't
on
it
the Lexus?
do it automatically too?
No, again, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches.
What?
At one point in time, I measured it. I don't remember off the top.
There's no way that the ride height is 1.25 inches. That's not happening. No. How low can it go? Low. How low can it drop? And then how high can it go? What is the variance of the ride height? But he asked, what's the lowest ride height?
My head.
So you believe it's 1.25 inches up and 1.25 inches down? How do you apply the 1.25 inches?
I recall the total being like 1.25 inches, but I measured it at one point in time. I just don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches? on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume
5 inches is
that
much more than an inch and a
the
quarter.
manual, as well as other informations, support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's the basis for the 5. What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine?
We've gotten to all of the really interesting questions today. These are the questions we all wanted to know. What ride height did you use? So you've got a car that can move 5 inches up or down. You've got a berm that's 4 inches. So you've got a lot of factors for variance in that blue paint experiment. And chat, if all of your takeaways are inches matter, that's where we're getting to. Inches and seconds.
Whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr.
I want to know about the
O'Keefe.
paint
If it
experiment.
was even possible. What did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
But that was parked.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus.
I'm
to
glad they
match that.
considered it.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document at all?
Stop flipping.
Yes.
Where?
Stop flipping.
Slide 107.
Can we have slide 107, Mr. Wolf?
And then if you could zoom in
I'm
on
glad
the
to know
lower
they consider
photograph,
it.
the
Truly.
gentleman with the blue shirt. Zoom in a little more, please.
Kind of surprised, actually.
So if I may, we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photos. So I don't care what the numbers are. I care that the height is the same.
Okay, so I just heard you say, if I heard correctly, you don't care what the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand. So what was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29th, 2022, while at One Meadows? And
I think this is the first time I've ever heard an engineer say, I don't care what the number is. And I'm kind of buffering on that. Because Okay.
colliding with the Chevy Traverse. What was the suspension height then?
We assumed it was the same as when it was at the Canton Police Department.
Parked.
Exactly. You assumed, but there's no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the tail light on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Well,
Doesn't it lower when parked? Didn't you just testify a few minutes ago or seconds ago or whatever, because time is a construct and apparently numbers don't matter, that it lowers when parked? And wasn't it in fact parked at Canton PD? So you're assuming it's parked when you just said that it lowers when parked and raises when you turn it on for drive height. So how can you assume it's at the parked height when it's driving? What? No, we assumed it was just at the lowest possible height. Did you run the models at 2 inches higher or 3 inches higher or 1 inch higher? You have computer models, right? So did you just run them at all the different levels to just cut off the line of questioning? Because you got paid like $320,000, so you seem to have time to just run the computer models. It's like my kid playing Civilization. He's like, what happens if I do this? What happened if I do that? Run it back. Let's start a new game. Do it this way. They're computer models. Just run them.
that information isn't very good because the vehicle had to go from Canton to One Meadows.
On a
And when the
flatbed.
vehicle drives, the way the suspension system works, it's automatic. When you go above 20 miles an hour, the suspension comes up, and when you turn off the vehicle, it goes down so you can get out easier. So it would be improper to assume that the suspension at One Meadows would be the same at another location.
That's the only, sorry.
Was there an objection? No. Go ahead and answer, please.
That's the extent of the information we had. We had it when it was.
Bullshit. That's the extent of the information we had. Bullshit. You bought an Exemplar Lexus. You bought one. So you could say at this height it's this, it raises to this, and it raises to that. You bought a Lexus to do this with. That's the information we had. BS. You had access to more information. You had the reports in your fingers. Also, I saw a few of you in the chat say 320,000. That can't be real. You're correct. I don't know if the 400 or the 44,000 that they got was a retainer that goes towards the 325,000, or if it's more, but it's 325,000 plus is what he said in his testimony yesterday. So it could actually be more than that. But I assumed the retainer was against the full amount, but it could be added to. So I was estimating on the low end and trying not to be hyperbolic. So that's the low end.
At the Canton Police Department,
Plus
we
the
matched
Lexus.
that height.
Sorry, sir.
That's all the information we had, he says. You had a Lexus. You had an Exemplar Lexus.
Sorry.
Was there an objection? No. Go ahead and answer, please.
That's the extent of the information we had. We had it when it was at the Canton Police Department.
That's-
We matched that height.
Sorry, sir. I understand.
But actually, you brought up a good point. It's going so slow when it's backing up that it wouldn't raise up. So the static position when it's backing up would be the static position.
But it wouldn't be
just
going
walked
in
right
back
into
up
that.
from the Canton Police Department to One Meadows. It wouldn't be going back up when it's going in other locations.
You said it was going over 24 miles an hour when backing up.
Sir, right? It would be driving
But that's on him. He's like, well, actually, it wasn't over 20 miles an hour backing out of the driveway. It's a fair point.
forward. It had to get from point A to point B.
Right, but as you pointed out, when you turn it off, it drops down.
It's a fair point.
And then you turn it on, and then once you go above 20, as you indicated, it goes up. But when she's backing up, she never goes more than a couple miles an hour. So it's going to be at the same position as when you
That's
start,
fair.
which is approximately the same position when it's off at the Canton Police Department a couple days later.
Okay.
Do you know whether the suspension
Now let's
system
talk about the other one.
locks when there is testing.
We're talking about two different points of time, chat. He's talking about One Meadows when she's backing up. She's backing up very slowly at One Meadows on the video. He's talking about the One Meadows backing up being under 20 miles an hour. I think that's fair. Still an assumption, but I think that's fair. Saying, well, if it doesn't raise, the thing that concerns me more is that he doesn't seem to have thought about it until now. I'm more concerned about that. But that's different than the backing up at 34 Fairview. The backing up at One Meadows is slower. And that's a fair point.
Of the infotainment system.
But he didn't examine it.
Suspensions? I don't know.
Okay. Let's go.
I'm going to back up Alessi's question because I soliloquied in the middle of it. But for him, he's just, well, actually, this.
System locks.
Does
when there
the
is
suspension lock?
Testing of the infotainment system.
Whether the suspensions? I don't know.
Okay. Let's go on to the next topic. You're aware of the vehicle control. Excuse me, Your Honor.
I bet somebody at the defense table wanted to point something out to Mr. Alessi, which is why he said, excuse me, Your Honor. We can't tell because it's not on camera, but
Thank you, Your Honor. I want to go.
that's why he would
I'm changing
pause.
topics to go back now to Fairview, 34
Somebody has a
Fairview.
right.
You don't
Right.
know what the suspension ride height at 34 Fairview was on January 29th of 2022, do you?
Correct.
So therefore, if you don't know what the
That part.
suspension height was, because of course you weren't there on January 29, 2022, there's no measuring stick, as you say, you assert that you would have accounted for it in your methodology. So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
All right.
Did she put the car in park? Because he would be able to see if she put the car at park. Because it was one key cycle. If she parked the car, would it lower? He had an exemplar Lexus. He should have thought about it. I think the bigger point for the defense is that they didn't consider it at all. They didn't consider it at all. But you can see on his spreadsheet when the car's in park, it has each of the transmission states in there. So if the car was in park, when would it lower down in park, or only when the car is turned off? And chat, you might know the answers to this. He needs to answer it for the jury. And if she starts driving forward, would it rise up? Sorry, I'm going to start singing. Would the car, would it hover and launch into space? Would the car rise up and move forward? And then would it go even higher over 20, when it went over 20 miles an hour when it was going backwards? Where are we in that? And was it factored for? Because if you bought the exemplar Lexus, you have the ability to get in the car and test all of these things. And did you think of it? Because if you want to bump into your arm with paint, then shouldn't you consider all of those different height variances? One would think yes. Also, for everyone who sang Rise Up at the same time I did, thank you, my nerds. We are in the same place.
Talk about key measurements, such as the spoiler on the top of the Lexus and the inches that are important as to whether things such as, is there a contact with the front eye? You don't have some data that would be relevant to that calculation, the sum data being the suspension height of the Lexus at that time, do you?
So we have some data. We have photos of the vehicle 2 days later. We don't know the exact height outside because, as you alluded to, we don't have a measurement on January 29th of it, but we do have it 2 days later. That's the source of the measurement.
You don't have the suspension height or the setting of the suspension of the Lexus that existed on January 29th, 2022, do you?
Correct.
Now let's go on.
So it's not in any of that data? Is the suspension height not measured then when there is a trigger event?
To another topic.
Well, they definitely didn't consider tire pressure in the cold. And I learned the hard way when moving to Tennessee, when it gets cold, tire pressure can change considerably given cold weather. I had no idea.
Within the
I
34
had no idea.
Fairview on January 29th of 2022, I'm not going to go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of the hydraulic system of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It doesn't change anything left to right. It doesn't change anything down the side of the car.
Understood.
Isn't literally everything that is important to your analysis dependent? Isn't the most critical information to your analysis for the collision with John O'Keefe related to vertical height? I can understand width when it comes to 34 Fairview, but when it comes to, or One Meadows, when it comes to 34 Fairview, though, vertical height is what matters. Whether the spoiler hit John O'Keefe in the face, whether or not the arm lines up with paint the way that you showed that it did. Changing just a few inches matters. And you said yesterday that the reason you couldn't put a dummy behind the SUV is because there are too many variables to have a predictable, reliable result. And when you were talking about too many variables, it seems that you didn't even consider the variables of the height of the car and the height of the berm. So John O'Keefe could have been flat on the ground, standing on the ground, or standing at street level. He could have been standing on the berm. He could have been standing on the lawn. Is the lawn also 4 inches, or does the berm go over the lawn a little bit and the lawn sinks back down? Could it be 3 or 2? We don't know. And then, is the Lexus at the lowest level of suspension or the highest level of suspension? And how many factors are there if you're taking the Lexus at full suspension and then an inch down, an inch down, an inch down, an inch down, what, 4 or 5 variables? And then where John O'Keefe is standing has 3 or 4 variables. So statistics nerds, when you have 5 variables plus 3 or 4 variables, how many possible combinations do you have? And were those all considered? No. It's a good cross to allow them to make good arguments about the fact that there are too many variables. And this witness said it yesterday. There are too many variables for us to do a crash test dummy test because we cannot consider all the variables.
But for the measurements that are affected by vertical, you didn't have the suspension height of the Lexus system on January 29, 2022.
Again, I only know what it is 2 days later.
So now let's go on to vehicle control history. Sir, you understand what I mean by vehicle control history of
This is
VCH?
text stream information?
I think
Are you
the height
aware
of the
of
vehicle
what is called the Bosch crash
very
data
important.
retrieval system in Lexus vehicles?
Of course.
I was less concerned about the physics. These variables are much more interesting just to me. Madeline in the chat said 20 scenarios. She's like, you just multiply them. Too many variables is what he said yesterday. And I think when they get to argument, because unless he can't soliloquy in the middle of cross, when they get to argument and when they get to ARCA, this is where it comes up.
We showed it on my slides.
And the Bosch
Back to the
crash
slides.
data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So, can you answer that with a yes,
Yes or no? No.
Is the Bosch crash data retrieval system the black box on Lexus vehicles?
No.
I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the
No.
question was just asked.
I'd like him to be able to finish his answers. No, he can answer yes or no, like everyone else on cross-examination.
Answer that question.
No, it doesn't make sense.
Okay, next question, Mr. Wilson.
Great. No.
I'm going to ask the question, sir.
I appreciate that the court did not let
The
him
Bosch
answer.
crash data retrieval.
The court did not let him answer. The court said yes or no. Good. The court will often jump in and say, let the witness finish their answer. Did not do that with this witness. I hope that that continues.
Retrieval system in Lexus vehicles. You're familiar with that? Are you familiar?
That's not you. That's not me. That's the feed. Why are we frozen? What are we doing? Why are we freezing? No, I hate all of this. It's buffering in real time. All right. The feed has had enough. Let me see if we can get past this in the feed real quick, and then I'll try to refresh it. I just wanted to see what my timestamp was. Give me 1 sec. Let me try to refresh this and see. The feed is over it. That's me being hyperbolic. Oh, the problem is I'm not going to be able to get back to the exact same spot. Let me see if I can get back close in time. I know it's fascinating watching me watch the feed. Let's try this again.
That it wouldn't raise up.
Okay.
So the static
Close.
position.
Close.
To do you?
Correct.
Now let's go on to another topic. Within the 34 Fairview on January 29th
we're
of
still-
2022,
we were ahead of
I'm
this a
not going to
bit.
go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of
I
the
think this is a little
hydraulic
behind where we
system
were.
of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It
Right.
doesn't change anything left to right. It doesn't change anything down the side of the car.
We're back just a little from where we were. So if you're watching this on replay or listening in the background, the feed buffered and I had to reset it. So yes, this is a little bit of an overlap. So it is redundant because I rewound.
Understood.
So we've heard
But
this.
for the measurements that
But
are
we're
affected
very close
by
to where we were, and I
vertical,
don't wanna miss
you
it.
didn't have the suspension height of the Lexus system on January 29th, 2022.
Again,
did you?
I only know what it is 2 days later.
So now
Okay.
let's go on to vehicle control history. Sir, you understand
That
what I
Bosch
mean by
crash
vehicle control history?
data
This is
retrieval.
text stream information.
Are you aware of what is called the Bosch crash data retrieval
And this is
system in
just where
Lexus
we were when it
vehicles?
fed.
Of course, we showed it on my slides.
When it froze.
And the Bosch crash data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So, can you answer that with a yes or no?
Is the Bosch crash data retrieval system the black box on Lexus vehicles? I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the question was just asked. Can you answer that question?
No, it doesn't make sense.
Okay, next question, Mr. Wilson.
I'm going to ask the question,
Okay,
sir.
you can't answer it.
The Bosch crash data retrieval system in Lexus vehicles, you're familiar with that? Are you familiar?
Well, refreshing didn't work. Let's see if we can skip past it and unfreeze it.
Lexus is a
All right. It unfreezes in there somewhere.
by Lexus as a diagnostic tool for their
I was
technicians,
so optimistic.
Lexus technicians, to assist in vehicle repair and maintenance. Is that what that is created for?
That's their stated purpose.
Right. And is a synonym for VCH TechStream?
Sort of. TechStream, similar, like Bosch is the hardware and software to access the black box data. TechStream is the software to access, for example, the pre-collision system, the PCS system, and the VCH, which is the vehicle control history. So TechStream which does a lot of other stuff, but does access that information.
You just mentioned Bosch, didn't you, sir?
So Bosch is not in the Lexus. You use Bosch stuff sold by Bosch, Bosch software and hardware, and you walk up to the Lexus with all the Bosch stuff and plug it in and download the event data recorder, the EDR, the black box. That was my problem. There is no
Understood.
Bosch stuff in the Lexus.
I understand, sir. That was going to be the question that I was trying to get to, but you've explained it, so I don't have to answer the question. Let's go to the VCH database that you say the
even the
stated
simple
purpose
questions are a
is
fight.
to assist technicians at Lexus in vehicle repair and maintenance.
So I didn't say that was a stated purpose. I'm saying that's what Lexus or Toyota says is a stated purpose. It's being used in litigation all the time. All I know is that's what Lexus and Toyota says. But again, it came about right when we started seeing all the sudden accelerations in the Toyota vehicles.
So my question is the VCH database specific to Toyota and Lexus vehicles?
So it's not a database, it's software.
Is the software specific to Lexus and Toyota, the VCH?
Those particular acronyms are, yes.
Want to move to another topic, and we are almost finished. We have just two more topics, sir. How common were VCH
I don't think he's telling this
events
witness. I think he's
when
telling
Ms.
the jury.
Reed owned
We're
the
almost
Lexus?
there, guys. Hang in there.
In 2022,
From, do you know the ownership period of?
I think that's a fair
Ms.
clarification
Reed
for the
with
witness.
respect to the Lexus? Do you know how long she owned it?
I have that documentation. I do it off the top of my head.
Do you have an approximate?
No, I mean, it was a 2021 vehicle. Our accident's January 29, 2022. But I did get that information.
Do you know how many VCH events were associated with the Lexus of Miss Reed?
I did not count them, no. I have them all.
Do you
I was
have-
only focused on the ones around our time period.
Exactly. But
Exactly.
Do you have
How did you
the
decide what was the
number
time period?
of events? Do you know how many there were?
I could get it for you.
How long would it take, sir?
3 minutes?
Why don't we come back to it?
No.
And we'll see if it's.
How about I
No.
start this so that we don't have to wait for it to boot up? And then when we come back,
How about we just do it my way and let me turn on my computer and get it going so we don't have to wait? No. No. Mm-mm. 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 How about we don't do it your way because you're not the one in charge of cross-examination.
it's ready to go. You
As
okay
long
with
as
that?
that's all you're looking at, sir.
Yep.
Thank you. And then pick your head up, please, so I can finish these two
Please,
topics.
go ahead.
So
Pencils down, head up. Can you close the screen down a
how
little bit?
often
You're
were
not
VCH...
Pick your head up when you're ready, sir. We can clearly see that you're looking at your computer still. And it seems like it's booted up. Unless you should wait. Sir, I'll wait till you're done.
Events recorded on the Lexus before January 29th of 2022.
Man, I have to pull this data up.
Fair
to
enough. Fair enough.
answer that
I
question.
assume that.
He said, look up when you're done. And you said, okay. And now you're not ready.
That's going to be in what you're also pulling up.
That's the goal here.
I need Alessi to channel some band director energy.
Would the number be about 15? Does that sound right to you?
Stop asking him questions until he's ready. Just stop it. Alessi, just stop it. He's not ready. He's paying attention to something else. He's not ready to talk to you. Just stop it. Just stop it. He's not ready. He needs, Alessi, band director energy. A band director would never allow this shit to happen. Excuse me, can I just get some more water? No! Get back on your dot. Ugh.
Let's see. 1, 2.
My water polo coach would have thrown things at this man. But it was the 90s. I doubt water polo coaches still throw things at people. Maybe they do. Different times. I'm gonna sit here and wait. Emily, can you zoom? No, we're gonna wait. Because he's like off on his own. And I don't know what the fuck he's doing. And if I was Alessi, I'd be like, excuse me, can you tell us what you're doing? You said you were gonna boot it up. You're not booting it up. What have you started doing now?
There's 18.
Oh, you
18.
started counting them.
So there were 8, your records show that there were 18
Can you close it now?
BCH events recorded on Miss Reed's Lexus, correct?
Before the subject one.
Right.
Before 1162.
Did you
He can't.
conclude that any of those?
Well, fuck. I am so distracted now by looking at him looking at his computer because he cannot keep his eyes off of the computer screen. He cannot look up and answer a question. It is just,
Events other than the 1162-2 were a collision?
No.
Now let's go to reverse recorded events. Can you tell how many of those 18 events were reverse recorded events? And you know what I mean by reverse recorded events?
Yes.
The vehicle going in reverse?
Right.
How many of those events were the vehicle going in reverse?
And this is before.
4. Other than
He asked
No,
you,
I
is
said
this
before.
before?
yes,
Total.
I'm sorry.
Oh, I would have to pull up the PCS file.
Can you start that and I can continue on with the question?
no, he can't multitask.
I got to. So the PCS file is I have a second laptop that
Here's
has
what I'm going to
touchscreen.
do. That's not important for me to keep going and get through it,
Okay.
so let's just stay on the events, okay? Only one of all of those events, those 18, are you concluding that there was a collision associated with
pulling out
them,
of your
correct?
bag?
Just one.
No. All those.
Stop fidgeting with stuff.
18 are before. The collision is number 19.
No, I'm saying, I understand what you're saying, but for all the other events that are recorded, you're not, other than the January 29, 1162-2, you're not concluding that any of those were collisions, correct?
I didn't look at them. They were so far mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct?
Yes.
Sustained.
Let's go to 5:07 a.m. on January 29th, 2022 at One Meadows, the
Don't open that
home
fucking binder.
of Mr. O'Keefe.
Don't you open that binder.
Okay.
Ask permission.
There
Shut your
was a collision between Miss Reed's 6,000-pound Lexus and Mr. O'Keefe's 4,000.
I am so distracted by what he is doing on the stand. It is hard to stay tuned to his testimony. And unless he is asking questions that I so very much want the answers to. At 5:07, did the contact, to be fair and generous, did the contact with John O'Keefe's Traverse register? And he's just like digging around, doing whatever.
Approximately
I want to know the answer to this question.
between Miss Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided. They made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at
Good
34
questions.
Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man.
He's going to say that didn't register either because it didn't. This is not a good question, Alessi. This is not a good question because it didn't register either. He has said repeatedly that the trigger event was the backing up at speed, not the contact with John O'Keefe. Alessi, you are walking in to where you don't want to. This is not the right question. This is not the right question, Alessi. But you want us to believe that the glance to John O'Keefe registered. Wrong question. Nope. The backing event.
This jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No. The impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. They'll call stop codes and things like that. But that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred.
Right.
Because the tech stream doesn't tell you that.
Thank you.
You're welcome.
Exactly my point.
Right.
The tech stream information
Could have been asked.
doesn't tell you when a collision occurs, does it?
Correct.
Right. That was the question he wanted. I wish he had asked it just more simply and directly.
That's all the questions I have.
Oh, we're done with cross. I'm kind of shocked. I wish it was just asked more simply and directly. The answer is what I think Alessi was going for, which is you can't say where a collision occurred with John O'Keefe. And the answer is no. It doesn't register anywhere.
At this time, Your Honor.
All right, why don't we take our morning recess, James?
Surprising to me that we are at the end of cross-examination at the time that they took the morning break. I think cross went a lot smoother today than it did yesterday. That's not because the witness was easier. It's because Alessi took a bit of a different approach for most of the cross-examination. The points that I wanted to hear about, I think were mostly addressed. Alessi asked about something that the chat had been asking about all day yesterday. What about the suspension system? What about the fact that when the Lexus parks, it lowers down, and then when you start to drive, it raises up, and there are different suspension levels? How much variance is there in that, and was that considered? And the witness said, we used the suspension height from when we measured, not them, but when the measure was Lexus at, I think I said that backwards, when the Lexus was measured at Canton PD on February 1st. We used that height. Well, that's the parked height of the vehicle. So they did not account for the relative suspension height that can vary and change when they did the models of the Lexus backing into the Traverse and when they did the blue paint experiment, video, whatever, when the Lexus was backing at 34 Fairview. So the height variance of the suspension was not accommodated for, or it seems even considered. And the height variance of John O'Keefe, whether at ground level, at the berm, or the yard level, were not accommodated for. They also asked about whether or not the tech stream registered a collision event when the Lexus hit the Traverse, and it did not, which I don't think we had heard answered yet. And it also did not register any collision event with John O'Keefe, which we knew. Alessi also asked more about the, wait, where were we at the beginning? I totally lost my train of thought. Hold on. There was something else I was happy that he asked about. And then we got into the laptop and I got totally like laptop distracted. Let's see. Oh, the 3D models. And Alessi asked about the 3D modeling of the Lexus vis-a-vis the Traverse and how the 3D modeling was done and if the 3D modeling was overlaid, because some of the 3D modeling looks different. I think all of that is laying foundation for when we get to the defense experts. Maybe not so much for the answers being impactful to the jury at this moment. We also saw the groundwork that Jackson had laid in previous cross-examinations come into play here, because we saw a lot of questions early on about the glass on the bumper of Karen Read's Lexus and the assumption that this expert made that the glass found near John O'Keefe and the glass in the bumper were the same. And what we learned is that this expert thought that the lab results came back inconclusive. Well, the lab results did not come back inconclusive. And the jury would likely remember that well because Jackson made such a good chart. I found that chart to be incredibly helpful. It's memorable, and it really synthesizes the data about the glass on the bumper of the car and the broken glass found near John O'Keefe at 34 Fairview by the leaf blower crew. And you see that come back around when this expert says it was inconclusive. I remember the chart. No, it wasn't. And showing that those assumptions had already been disproven in other data is helpful to the defense to argue it down the road. And I think that the groundwork laid to get that chart in made that information much clearer than last time, because the jury sitting there going 3-3 and is it the same as 17 or 11-12 is so hard to keep track of. So the simplification of it, I think, was well done this time. We didn't see it last time. Somebody in the chat said, Emily loves Jackson so much. Oh, no, not all the time. Only sometimes. Sometimes he annoys the crap out of me. But that's true with all lawyers. Sometimes I'm delighted. Sometimes I'm annoyed. It is the true with all things. I am very ADHD. I think that chart was great. I think it was worth the effort. I also find, for me, that the side that can make things more clear generally has a better time with the jury. And if you cannot make things clear, then you go a long way to confusing the jury. And if it's the prosecution that is the one that is confusing, I think it is difficult for the jury. It is the job, I think, of the prosecution to streamline things and make them as clear as possible. And that's totally because that's the way that I saw it when it was my job. Am I always going to be harder on the job that I had? Yeah, I am. It's the job that I had. So I see that job in a very specific way. And I am very judgy about it. It is very much the job to make it simple. And I get frustrated when prosecutors don't make it simple. For the defense, I see that differently. And it's not that I give the defense more credence, it's that they have a different job. The job of the defense is to poke holes and to raise doubt and to raise questions. So it's a very different job than the job of the prosecution, which is closing the loops, closing the doors and saying, this is the one thing that happened. So those two jobs are very different. So I see the roles of those attorneys very differently. And when the defense is raining down confusion, I see that very much as their job. Could be this, could be this, could be this, could be this. That's their job. It is their job. The prosecution should have clear enough evidence that all of the could be this, could be this, could be this, has the jury going, that's not what it is at all. And when they don't, when the evidence is not clear enough, that's where the defense can make a lot of headway. So let's continue on to redirect after a very long morning break and see what areas Brennan keys in on. Here's what I think. I think Brennan will key in on the collision or not collision at One Meadows, the backing event and the speed and how much throttle there was at 34 Fairview. And I think he'll probably end his redirect with the opinions again. So what time does trial start today? We are halfway through the day, I would imagine, if not more than halfway through the day, because I thought cross was going to take much longer. It's gone much faster. And this is this is the only witness today. So let's get back after the morning break and resume.
Please be seated. Court is in session.
I mean, hear ye, hear ye. Court is now in session. So
The redirect, Mr. Brennan?
Thank you. Good afternoon.
Good afternoon, Mr. Brennan.
You were asked some
Actually,
questions.
it's morning, but yes.
You were asked some questions about the ring video from Meadows, which was John O'Keefe's home. And you were asked whether you're aware if the cameras had changed over time.
Correct.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions?
right into the conclusions.
Relative to that touching
I thought he
between
would
the
wait.
cars.
Absolutely not. It would have shown up as increased error when we overlaid the point
Well,
clouds.
that's the first thing I thought he was going to
onto the
touch on. And there we are.
photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the
Right.
information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a
Brennan's going to be like, see, this is all smoke and mirrors. None of it matters. It's all fluff. That's where he's going with this.
button and stand there and watch it.
He
and the
does a good
laser
redirect.
Does its thing.
It just depends
So
on if
I
the
have
jury's
absolutely no reason to
on his
disbelieve it.
side with that.
Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
I don't think that's a serve on the hydraulic information. You guys let me know. On the video information, I think there's other things I'm curious about with the video and One Meadows, but with the suspension information, I find it really persuasive. Tell me what you think. Maybe it's because I get into a car that does that, but I find it really persuasive that he didn't even seem to consider it. So for me, the suspension is way more of a serve than the camera variances. Let me know what you think.
Yesterday, you were asked a number of questions about formulas. You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing with...
I thought we were going to get a full 12 hours without having to talk about spreading our loads out. No, we didn't. No, we didn't. We didn't make it. Y'all let me know when that wanders its way into the next SJM book, Rebecca Yaros. You guys let me know immediately when someone talks about spreading their load. Let me know. Because it's going to end up on our second Audible accounts. And you know it is. You know it is. It's just a question of which series. But we're back. We're just back to distributed versus direct loads. But a lot of you in the chat said that you found the suspension to be a miss. I don't think Brennan has cured that nearly enough. But maybe Brennan's trying to skip over it so we don't Streisand effect how important it is. I think it's a really important point. All of you are saying, can we just call it force distribution? Well, that would be less funny for us. So I'll allow it because it's funnier for us. And every now and then you need a minute.
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing with, forces on your body. If you take this pencil, I don't have to press very hard for it to pull in. But if I spread it out, I have to press much harder.
You wanted to say penetrate,
So
didn't you?
You have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both 5 pounds, but you'd much rather get hit by the pillow than the 2x4.
If it's a 5-pound pillow, not necessarily. I mean, it really just depends on what you're into. I don't think you need to be deciding what we're into, sir. I mean, let everybody live their own life. But I think the analogy is well made for understanding the difference in the defense's questions. I just don't know if it's I just don't know if it's helpful.
You asked questions about communications when you would have communications with the Norfolk County District Attorney's Office. Did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
Brennan!
No, I don't have any of those.
So the form of the question,
Brennan. Well, we know that the Cross of Arca is going to be spicy.
But you'd much rather get hit by the pillow than the 2x4.
I backed up.
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
So argumentative.
I don't have any of those.
So the form of the question,
It's argumentative. It's leading.
When you were
it's
communicating with
compound.
members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
Objection to scope, Your Honor.
I'm going to allow it.
She's gonna allow
No,
it.
I mean, I don't.
It's not outside the scope. Unless he asked, did you communicate with the DA's office? The issue was to hide. That was the issue in that sentence. He's allowed to ask it.
You know what that is?
Would you ever use an encrypted app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Sustained.
You were
He said he
asked
didn't use
about
them.
confirmation bias. You remember those questions?
I do.
Could I have slide 33 of your PowerPoint, please?
Brennan's coming in hot, and I imagine Brennan knows that there were
Slide
jurors
33.
that discounted ARCA entirely last trial, and he is going to lay the groundwork for this expert to be relied on
second.
and ARCA to be discounted. That's exactly what he's doing. I'm just surprised I shouldn't be, but I'm surprised he tried to do it the way he tried to do it. But should I be? No. Shouldn't be surprised. Thank you, Matt.
33.
I'll pull that up when
could
we're
zoom
not
that
on
in, please?
slides.
A little larger so we can see it.
Can you embiggen it?
I cannot do it.
We're disappointed with
one
how
monitor.
small it is.
You can't do it any closer than that?
No. Not since I took down. Oh, hold on. Here we go. Which part do you want me to zoom in?
Miss Gilman can zoom in for you.
Sorry?
Fucking hell.
Which part?
Miss Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse, does that data
Dr.
suffer from
Barbara.
confirmation bias?
Always.
No, that's strictly electronic data.
When we look over at the vehicle speed, can we go to the left a little bit?
I think this is good grounds for
Yeah.
redirect on these questions.
Vehicle speed ending at 2361 miles per hour. Does that
He didn't
suffer
say
from
fucking hell. I said
confirmation
fucking
bias?
hell.
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on in the slide, but that is a direct reading.
Oh, yeah. The Make of Time in the chat said, FYI, most companies use encrypted software for their emails and should. Encryption's not like a bad thing. And you can still track the emails that are sent. Was the $320 plus $1,000 contract, was that encrypted when it was sent? Or was it just like a PDF? What are we doing? Was it an encrypted PDF?
From what the speedometer is seeing.
A younger jury will be less
Acceleration at the
dissuaded
end
by
of that
that. An older
10-second
jury
window,
might feel like it's
74%.
more nefarious.
Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
Those are good questions from Brennan. Because 74% on the throttle is a massive number. And the jury's going to be like, that is just put that pedal down. And Brennan is going to argue it a lot in closing. Those are good questions. Now, I still have questions about how you can go 87 feet backwards and not hit some shit. But that number is one of those shocking numbers that he wants the jury to remember. And I stepped right on his question because he's moving so fast, but that's a really good question.
Seeing.
Really good question.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Whoa, what?
Anything, Mr. Lessie?
Brennan just
Yeah, Your Honor.
Yes.
Thank you.
Brennan just went whoop, just whoop. It's a real good redirect. I think Brennan has leaned into, 74% on the throttle. That's a direct readout from the car. But I am real surprised that is how fast he was done with redirect. But the strategy here, and we're going to talk about the strategy here for a second. The strategy here from Brennan is to keep it incredibly short, to argue later, this is all distraction. This was all distraction from the defense. And there will be jurors who will look skeptically at the defense for everything that they do. There will be jurors that look skeptically at the prosecution. It just depends on where they come in to jury duty from. And there's some that are just like, it's been 6 weeks, I'm exhausted. But he is leaning into all of this is fluff. All of this is fluff. It's not important. I'm not even going to address it because it's not important. Those are the readings from the car. That is a foot slammed down on the accelerator. I don't need to ask anymore. That's it. So that's Brennan's strategy for not even giving breath to a lot of the things that the defense asked. Because I think Brennan really wants to get to cross-examination of the defense witnesses. So he is trying to show, and this was just said really well in the chat by Rasputin, Brennan is trying to show Cross was irrelevant, so he has nothing to tidy up. Yes, 100% his strategy. How well that will work depends on how the jurors received this witness. If the jurors like this witness, they're going to be like, yeah. It's a solid strategy, and it's a good redirect for Brennan. There are questions that I am still left with, but that's me. Brennan was just like, 74% down on the accelerator. I don't need to say anything else. I don't need to say anything else. So let's continue on with recross, which will probably be brief because recross can only address what was brought up on redirect.
Dr. Welcher, you were just asked questions about slide 33, which is the slide about text stream data. You acknowledge that text stream data, what you have called a trigger, like was on that slide, does not tell you if a collision even occurred.
I think that's
correct?
outside the scope.
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct?
Bing.
All that's on that slide is data, correct?
How do you ask me more questions than just this slide?
But were the questions
you know
just
what he
about
means.
data?
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So
We know you can answer a direct
generally,
question.
yes. Again, I started this case with
It was
the
just a question.
hypothesis.
Go ahead, sir. Go ahead.
With the hypothesis that the Lexus didn't contact Mr. O'Keefe. And so I start what's
first time
called
he
the
said
null
that.
hypothesis, that this didn't happen. And then I look at evidence to either include or exclude the null hypothesis. So theoretically, my confirmational bias starts with a bias that it didn't happen.
I think that's the first time he said that.
One document.
And that's a good answer from this witness. It's why you don't just let them go. It's why you don't just let them go. That is a good answer from this witness. It's why you try to keep it to yes or no, because he's going to just run with it. He hadn't said that this entire time.
Shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe to the point for one document. Was there one document on your slide presentation that analyzed the null hypothesis, as you call it, there being no contact at all? Was there any slide?
Questions are too long, Alessi.
So
You got to keep it
remember
short.
what I said. We start with hypothesis. We get more data. We whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already.
Ding, ding.
So I didn't include everything. There's
self-awareness is
thousands of
gonna win
photographs
points, though.
in here. There was a bunch of testing I did with the Lexus about backing, pedestrian detection that, you know, removed certain hypotheses. So if I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about your...
All the slides show that, to answer your question.
Sir, my question is there
Alessi,
any slide
we
that
got to keep it
says
less or more right now.
alternative hypothesis to whatever the label is, whatever the term, it says no contact between the Lexus vehicle and Mr. O'Keefe. Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
He didn't
And-
explain it in direct at all.
To work through hypotheses, different ones, and to see whether there's confirmation bias, have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis?
He's
and
not gonna work with you,
how and
Alessi.
why you rejected them?
Leave it, my opinion, leave it for your expert. Nail down the points you need from him and leave it for your expert. So, this is what I would like to see. Because the prosecution, I think you can argue with the confirmation bias, opened a little bit more space in recross, because you can only address in recross what was addressed in redirect. Opened up space to say, so you assumed the height of the Lexus, but you don't have that data. You assumed that John O'Keefe was on the street, but you don't have that data. You assumed, and do a bullet point list of all of those assumptions. So these are all the things you had to assume to come to your conclusions. Yes. Yes. Okay. Done. Because that is where you show the confirmation bias without asking this witness. So you don't have confirmation bias. What do you think he's going to say? You know he's just going to talk around it, and you've already allowed him to explain himself more than he explained elsewhere. Don't let him explain himself anymore. I understand you didn't have all the data. So these are the things you had to assume based on other information. You chose those points and show the choices he made. And then argue those choices with your experts, not with him. Ask your experts about the confirmation bias, not him. You had to make all these choices. That's all you need to lock down. Yes, you did. Great. Don't give him room to run.
Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that
Okay.
context. It's probably, I understand where you're going with it.
Thank you, sir.
So do we.
No further questions.
Oh, Alessi, no.
Welcher, you were all set.
Oh my God, thank you.
The whole courtroom, it sounded like laugh.
Give me a minute to pack up and I will be out of here.
Well, he just seemed right thrilled. OMG, I'm done.
Oh, I am plugged in, yes, thank you.
I am surprised that that's where Alessi left that redirect. Alessi should have known he wasn't going to get anything. Did he just scream, oh my God? He sure did. Do you want to see it again? Because we can then zoom past it. The court said, you are done. He was just like, great. I can get back to looking at my data on my computer.
Give me a minute to pack up and I will be out of here.
You can't stay here, sir.
Dr. Welcher, you were all set.
Oh my God, thank you.
Everybody laughed,
Give me a minute to pack up.
which means there are some in the courtroom that do not dislike this witness. Because if jurors, it might have been the audience laughing, but it could have been the jurors. If jurors dislike a witness, they're not going to chuckle when the witness tries to do a funny. They're going to be like, really? It's like when someone you don't like tries to be funny, you're just like, ew, no. All right, he's going to pack
I'll
up.
be out of here.
The Commonwealth will probably rest, I imagine. And then we'll see where we get.
Yes, you can.
So we will see. Some of you chuckled, some of you didn't, right? Exactly. A number of you said the judge is smiling. I think the judge is smiling because it's fucking over. He's done. It's being in court for a cross like that is exhausting for everyone. It's exhausting. But that recross was not super helpful. I think the redirect was much better than the recross. I think there were parts across that were good. I think the parts across that were good build foundation for other things. They are not going to be those aha moments for most people in court. They will be a slower burn, but that tends to be more of a Leslie's style. No one's happier than the court reporter right now that this dude's done. Also, he answered his questions so directly on redirect and was so evasive on recross. And I don't like it when witnesses do that either.
Mr. Brennan?
Oh, do we have more clips? I see a CD in your hand.
Commonwealth moves to introduce and play clip 26.
Clip 26. ID 41024.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
I was wondering if that clip would come in. We're going to watch that one more time because at the end of the clip, she says that her lawyer told her, then you would have some culpability. I was wondering if they were going to play that clip. I thought that they would. They might try to push Karen Read into testifying because those clips are not good. Do I like, let's differentiate my feelings and my lawyer thoughts. Do I like that the Commonwealth seems to be building almost their entire case on clips of interviews? No, I don't. I want to see a lot more. But are they doing it? Yes. Why are they doing it? Because she gave these interviews. And jurors may find them very persuasive. If jurors are sitting there going, well, how did this happen? And again, we're not to the defense case yet. But if jurors are sitting there going, how did this happen? She is saying, well, my music was blasting. The heater was blasting. He could have walked behind my car and I not seen him, not heard him. He could have gone to touch the back of my car, bang on the back of my car, and I could have clipped him. I could have hit his knee. I could have hit his foot. And I asked my lawyer, and he said there could be liability there. That is something that would never happen if she hadn't said it in a media interview. And they're following that up on the tail end of an expert who said The injuries to John O'Keefe are consistent with the vehicle, whether you agree or not. The injuries to John O'Keefe are consistent with the vehicle. The damage to the vehicle is consistent with hitting John O'Keefe. I have a lot of questions about that. But if there's jurors sitting there going, okay, this clip is a strong play for the prosecution, I wonder if this is the last thing they will use. Because for me, if the coroner is like, I can't tell you what happened, fair enough. But if there are jurors that are sitting there going, well, if she thinks she could have done it, then if the defendant thinks she could have done it, then I think she could have done it. Does that, for me, get you to account two? I don't think so. Or to a second-degree murder, count one? I don't think so. But does this go strongly to count two? Yes. To the involuntary manslaughter? Yes. That gives, and a lot of jurors were persuaded last trial on that involuntary manslaughter. So does this go to that? For some jurors, I'm sure that it will. But we're not at the defense case yet. But that interview clip is something that the defense is going to have to work hard to overcome. And these things could be pushing Karen Read to testify. I'm going to see a lot of questions, I'm sure, about, but can't they keep playing the clip? No. They are allowed to choose the portions they want to play. So the defense's options are to have Karen Read testify or to live with these clips and say, you don't have enough context. You don't have enough context at all. But the defense can't use the rest of the clips because as to them, it's hearsay. Their option is Karen Read testifies or they argue this. But these clips, they are allowed to play, and they argued over these clips in motions in limine. So, a number of questions of why can't the defense play the clips? Because it's hearsay as to the defense. It is not a statement of a party opponent. It is the statement of their client. They cannot introduce their client's self-serving hearsay. So let's continue on. We're going to play this clip again, but it is a big thing to distinguish between how a jury is seeing this case and how those of us that have watched this trial and all the pretrial motions see this case. It is a big difference between the two. And the jury is just going to get to make that decision. Why do we need it 3 times? Well, we don't, but twice we need it because I want to see it again. And I paused and talked a lot. Can you explain how they can play these clips outside of testimony apropos to nothing because the foundation has already been laid for them? It's a great question. The foundation has been laid for them. And so they can introduce them because they established that in motions in limine. They can introduce that how they want to. They don't need someone on the stand to say, I sat down and did this interview because they already have the foundation for them. So there's no witness to ask. They're clips. The same way if they had other clips, they could play them. So we'll see what happens. Tom said, what about the rule of completeness? They already argued over that. I think there's at least 1 or 2 clips that have not come in that the prosecution wanted, but they argued that the rule of completeness does not mean they have to play the whole interview. It means that the sentence has to be complete. It means that they can't splice or like Real Housewives edit things together. But it doesn't mean they have to show the question, the answer, the next answer. And that's something that they fought over. I think the defense is going to see these clips as she's wondering what the fuck happened. And they're going to argue that if they don't have her testify, they're going to argue that she's wondering what the fuck happened because no one knows. And neither do you. That's where they're going to argue it. So Scooby-Doo said, question, can they call the interviewer and talk about the clips? The defense can't call the interviewer and ask the interviewer what Karen Read said because it's still them introducing hearsay. And if it's them introducing hearsay of their client, they can't introduce it that way. So no. All right, let's watch this clip and see what happens next.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Then you have some element of culpability. That's what they wanted that clip for.
Exhibit 207.
That's being admitted into evidence as 207.
Your Honor, the Commonwealth rests.
And there they are. Done.
Does
Ding, ding,
counsel want
ding.
to see me?
Yep.
We do, Your Honor.
Okay. So should we send the jury out or should...
Yes. For the day. Because you're going to need to argue.
Jurors, so everybody can sit.
Yeah, they're going to need to argue.
The Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So I need to meet with the lawyers for a few minutes, so we're going to send you back out. I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So we'll send you back out for a short recess.
Rise to the jurors.
They're going to want to argue. The
Can
Commonwealth...
counsel come to sidebar, please?
No! They're going to sidebar. I have one question that I'm going to answer. Brittany, EDB, can you tell us your opinion? Is the Commonwealth's case stronger this time than last? I think they have presented it in a cleaner way. However, I know what is outstanding. They have presented it in a cleaner way. They have used the words of Karen Read to buttress their case quite substantially. I don't think it can be underestimated how much weight jurors can put on the words of the defendant. So it was presented in a much, much stronger way. However, that leaves a lot of room for the defense to point out what the Commonwealth didn't show the jurors. So there is a risk, I think, for the jurors to feel that things were kept from them. And one thing I know about jurors for certain, jurors do not like it when they feel like things are kept from them. And when the defense calls Proctor, I imagine how the jury feels could sway, because jurors do not like things being hidden at all. And we've heard the judge say, I know you don't like it when we're at sidebar. Why don't the jurors like it when they're at sidebar? They don't like it when they're at sidebar because things are being kept from them. And so when you get into all of it, they run the risk of being real frustrated with the prosecution hiding things from them. They might not be frustrated now. EDB, can defense use clips in closing and add context? They can use the clips that the prosecution used. Those are in evidence. They can use anything that's in evidence. They cannot use things that aren't in evidence. Do you know, Margaret asked, did she know she was being videotaped there? Yes, 100%. She was sitting down for the Discovery ID series that the defense team and her reached out to do. They initiated that series. Yes, she 100% knew she was being taped there. All right. let's see if they're going to argue their motions on the record and not at sidebar, because it would be real annoying if they just argued them at sidebar. I'd hate that the most. Let's zoom past whatever break they are taking, because I want to hear their motions arguments. Oh my God. What? Where are what? Where are the motion arguments? What? Where are the motion arguments? If they don't do those, are they going back on the record? Why is this still muted? The mics are still muted. What are we doing? What are we doing? They might do arguments tomorrow. That's fair. I just want to know what they're doing. I mean, they're going to make a motion to dismiss. It's going to be denied. And then, I mean, that's what is going to happen. But I would still like to hear them make their motions. And I want to see if they go back on the record. Everybody's in position to go back on the record, and the feed is muted. So we're just going to let's see. Alley Cat said ADB also doesn't like it when things are hidden. Correct. I don't at all. I know what I want to know. I think the defense said they had 3 weeks. They said a week and a half. That might extend, though. Are we going back on the record? Are we not going back on the record? And this feed is frozen. They're all sitting in court. Jury is coming back in.
Jurors, we all...
They're going to excuse them, aren't they?
Right, so jurors, we all... Happens several times a day, doesn't it?
More than several, Your Honor. More than several times. I'm sorry to everyone wearing headphones. That was particularly loud.
We don't want to waste anybody's time. I know we've spent a lot of time at sidebar, and we've had times that we've kept you in the deliberation rooms because we've been trying to sort through everything, trying to make this trial as efficient as possible, but also honoring and respecting all the hard work of the lawyers that's gone into preparing this trial. So sometimes I do understand that it's frustrating for you. But today we were able to spend some time this morning. I know we kept you in there almost a half an hour, and we've just spent some time now. So I can tell you that we are ahead of schedule right now. I still need to talk to the lawyers about something tomorrow morning. So we're going to send you home now.
They're going to argue in the morning.
And have you come back tomorrow morning at 9:30, because today I know we kept you until 9:30, and it doesn't make any sense where I already know I need to talk to the lawyers tomorrow morning to have you here for a 9 o'clock start. So tomorrow will be a full day, and we'll have you here ready to start at 9:30. Okay, so those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And also, please continue to be careful with your social media use. So we'll see you tomorrow morning.
Rise the jury.
Jury out. Court is done for the day. Defense starts their case tomorrow. And they're going to argue their motions tomorrow. I don't expect that those will be granted. And the defense will start with their witnesses tomorrow. So it's not unreasonable, I think, if they were going to have a half day anyway. It's not unreasonable to me that they're going to start their case in chief tomorrow. So at the end of day 23, the Commonwealth said they would be 23 days to present their case. It is midday on the 23rd. The Commonwealth has rested and they are done. The final thing they played in was a clip from Karen Read's interview with Discovery ID. And we did not see argument on the motion to dismiss that will be made by the defense at the end of the Commonwealth's motion. That will be argued in the morning. I don't think I've ever seen a case where the motion to dismiss at the end of the case was granted. I'm sure it happens. I just haven't seen it. So the defense is going to start with their witnesses tomorrow, full day of court tomorrow, with the jury coming in a half hour later to accommodate for those arguments, which means we will be here on time for those arguments. And who will the defense start with? Is what I want to know. Do they start with Proctor? Do they start with Higgins? Do they bring in the Alberts? Or do they start with Arca and bring in their witnesses to rebut what the jury just saw? Do you go kind of toe to toe with the accident reconstructionist, or do you bring in, if you're the defense, the argument over how bad this investigation was first and go from there? It'd be interesting to see. So who do they start with tomorrow? I don't know. We're going to find out. And I just have to wonder, would it be more helpful to the jury to hear about the investigation more first, or to hear about the accident reconstruction? But some of that's going to have to do with ARCA's travel days and when they're going to be able to be present. And that, I imagine, is what the defense is going to work on the rest of the day today. And then we get into the defense case in chief tomorrow, day 24. They said they had about a week and a half. It might go longer depending on what happens if they call Trooper Proctor. I can't imagine the defense doesn't call Trooper Proctor. And then we know that there will likely be some rebuttal from the Commonwealth. They have a dog expert that will be a rebuttal witness. They have asked the court, and the court told them they could bring Welcher back on rebuttal. So there are rebuttal witnesses that will come in from the Commonwealth. So when the defense is done, there will still be rebuttal witnesses. So we're not done yet, but we are getting into the defense case tomorrow. We also, from the defense, expect to see, they have a new expert. They have Dr. Russell, who will testify about the injuries on John O'Keefe's arm, plus ARCA, and then law enforcement and what law enforcement witnesses they might bring in. And they might start with the law enforcement witnesses and then ARCA and the scientific witnesses at the end. Some of that's going to be timing. I'm interested to see which direction they choose to go in tomorrow. I'm real interested to see. So we'll watch the argument. They gave it about a half an hour. The judge is going to say that a reasonable jury can conclude there's enough evidence here to find these counts. That's not surprising. I think that there are difficulties, to put it mildly, in the Commonwealth's case, but you have an expert saying that the injuries are consistent with the collision, that the damage to the vehicle is consistent with the collision. You have the gas pedal and the voicemails, which is what I think the Commonwealth will argue goes to second degree for count 1. And when the court evaluates this, the court takes everything in the light most favorable to the Commonwealth. So if it's could be this, they take everything in the light most favorable to the Commonwealth for that motion, including Karen Read's statements. Those are in evidence, including all of the witness testimony. So there's a lot this jury does not know. It's a strategy from the Commonwealth that I don't know how will play out. Because last trial, the strategy from the Commonwealth was mention it all. Literally. Where is it, Emily? Literally.
Mention it all. Mention it all.
It felt to me like Attorney Lally said, this is every name that's been mentioned in any police report ever. And I am going to call every single witness. And I was critical of that too. There were some witnesses that were just not needed. But Lally was just like, we're calling everybody. Literally everybody. There's not going to be a name that this jury hears that is not going to have somebody sitting on the witness stand and is going to testify. Every single one. That is not the strategy this trial. The Commonwealth narrowed it down significantly to what they think are their critical witnesses, but they left out some witnesses whose names have come up over and over and over again. And I have to wonder what the jury thinks about Proctor. Does the jury think former Trooper Proctor means he's been terminated? Or does the jury think former Trooper Proctor means that he is no longer with us? What does the jury think about why the Commonwealth hasn't called them? Because the jury will fill in the blanks from their own life experience. And if any of the jurors are sitting there going, oh, well, they didn't call him because they can't, it's going to be a real surprise if the defense stands up and says, we would like to call former Trooper Proctor. I think former indicates that he's been terminated, but I think a jury could also think that he's unavailable to be called because he's deceased. I think there's room for them to think that either could be true. So wouldn't it be real interesting when the defense calls and then the jury is like, what? What do you mean you didn't call him? Jurors do not like feeling like things are hiding. And so the strategy of keeping out Higgins and Proctor and Albert and, I mean, even Ricky, whose truck it is, could go badly. So we will see. A number of you have mentioned, but the defense said in opening that Proctor was fired. Yes, but that doesn't mean that he can come and testify. So the jury thinking that Proctor's not been called might not have to do with them thinking he's been fired, because it could be a yes and. So I think at some point the defense has to call Proctor. And I don't know how, as that comes in, the jury will feel about the prosecution keeping that witness off the stand. I think it was a very difficult decision. Maybe it wasn't. Maybe Brennan's like, fuck it, we ride. I think that's a very difficult decision for the prosecution once they made the decision that they were going to re-prosecute, even in light of Proctor being fired for behavior in this investigation. So how do you, as a prosecutor, make the decision to call or not to call Proctor? Well, you can choose not to prosecute, but choosing not to call Proctor may have more sting when the defense calls Proctor. How, if you've never seen this case before and you've heard the name Proctor, and you've heard allusions that he's fired, but you haven't seen the Commonwealth call him, and you know that he was centrally involved. He touched all of this evidence. Proctor. And the Commonwealth doesn't call him, and you're like, okay, they didn't call him. And then the defense calls him. I can't imagine just being like, why didn't you show us this witness? What are you hiding from us? But it's hard for me to take a step back in that because I know what Proctor's texts say from the last trial. And knowing what the texts say, I think I feel more strongly that, like, what are you trying to keep from me? So we're going to watch it play out. For all of you that haven't seen the case before, you've heard the name Proctor. And then the defense is like, we call Michael Proctor. I think that becomes a mic drop moment for the defense. So we will see what they decide to do because it's a bold play for the prosecution not to call Proctor, and it might blow up in their face. So we're going to have to wait and see how it plays out. But I'm I'm ready to see it. Call Proctor first. Let's go. Let's just go. Let's just call Proctor first. Let's just do it. But I don't know if that's the solid strategy. That's what I want to see happen. That's just purely selfish. Emily, is that legal strategy? No, that's purely selfish. Bring them in. Put them on the stand. I want to hear what they're doing. Yeah, purely selfish. That's just, I want to see it. I'm ready. So, will they call Higgins? I don't know. I think they have to call Proctor. I think Higgins is more on the bubble because you don't want to get too far into the weeds. A lot of you have asked, and I see a number of you, including Amanda, saying, Emily, who would you call first? It's hard because lawyer brain would have to think about it more. Content brain is like, call Proctor. All of us are ready. And then you've got to think about having the weekend, right? How much can you get through with Proctor on Friday to leave the jury over the weekend with Proctor's text messages and not even get to cross? And then you lay out for the jury how bad the investigation was, how outcome determinative or confirmation bias it was, and then you end with your accident reconstructionists to juxtapose, because you just got to the confirmation bias in the experts. So do you bring in Proctor to show where the defense is going to argue that bias started from? Do you bring him in first to go stink from the head? We'll see. I'm going to do a poll. A lot of you have asked. As a reminder, hey, Megalina, can we just put up a pinned message that court is over for the day? Thank you. I'm going to put up a poll for those of you that are new here. Hi, welcome. Good to see you. Welcome, Lawnards. I do not poll on questions for the jury. I do not. I will poll later on whose case you found more persuasive, whose closing arguments you liked better, those kinds of things. But I do not poll on guilt versus not guilt and how the jury's going to vote. It's a personal preference for me. But I am going to poll on, do you think the defense will call Proctor first or should? No, let's go with will. Do you think the defense will call Proctor first? Oh, no. Let's do when do you think the defense will call Proctor? And I'll put in a first and last option. Let's do that. That's better. When do you think the defense will call Proctor? First witness, first wit, last wit, won't call him. Those are our options. All right, first wit, last wit, won't call him. There we go. I don't think they'll bury him in the middle. I don't. It's too important for them. All right. Some of you are saying, can Proctor plead the fifth? Not unless there's stuff we don't know. He didn't last time. It would go question by question. It would be outside the purview of the jury. Since court is done for the day, we have time to answer some questions. Let's get to some questions, shall we? It's time. It's time to get to some questions. I think we did a summary of the day. I'm pretty sure we did a summary of the day. So, I mean, tune in tomorrow, get the Lawnard app, subscribe to the channel, do the things. And Lawnards, the team let me know this morning that a lot of you were like, what the heck is going on with the chat? There's like new stuff. I've been asking. I don't know. I had no idea. I don't know. I'm trying to figure out how I can turn it off. I don't know. There's new stuff. We didn't turn it on. We had no idea. So we don't know. We're asking. All we can do is ask the questions. All right. Let's get to questions, shall we? Yeah, I don't even know if all of you can see it. Some of you have seen it, some of you haven't. There's new stuff. But if you don't see it, it's because you don't see it, and that's fine. Let's see. Julie B said, Emily, why can't I watch you off YouTube? Because I stream on YouTube. So the streams are on YouTube. You can listen to the audio of the podcast and quick bits on your favorite podcasting app, but I stream on YouTube, so you have to be on YouTube. Hopefully that helps. Casey Cat, thank you for the gifted memberships. That's incredibly kind. Presumed Hostile said, what a long, strange trip it's been, y'all. Yes, it has been. Oh, not Quick Bits. Sorry. The Emily Show podcast, formerly known as Quick Bits on the Emily Show channel. We renamed things, but my brain has not integrated the information yet. But on the Emily Show YouTube channel and the Emily Show podcast on your favorite podcasting app. Yes, thank you. Let's see. Mary Lou Crafts, I thinned 70 pounds of peaches listening to this guy, and his physics don't match my physics. It was a lot of testimony. Valkyrie Art said, Emily, I heard Brendan filed a motion yesterday. Yes, he did. He said that he needed to be given all of the information for impeachment. The shit's kind of out of horse on that because they're done. So it's kind of moot at this point. So it's the court hasn't ruled on it. If the court rules on it, we'll talk about it, but it's basically moot at this point. Laura, I'm so glad to be here with y'all. It's finals week. Still have a 4.0 for my paralegal studies. Congratulations. 6 classes done after this week. Huge love to the mods, EDB, and all the friends in the chat. Congratulations and good for you. It's so needed. Let's see. Ashley said, if Alessi wins this 40-year, what happens? Well, he would have been able to ask more about Trooper Paul's report and what was relied on. I wonder if the defense decides to throw Trooper Paul in there to show that the prosecution's theory keeps changing. Like if I'm the defense, I might call Trooper Paul too. Why not? You got time. So we'll see. Welcher has already used the slide. So does this open the door for introducing Paul's testimony? It would open the door to ask questions about Trooper Paul's report, not Trooper Paul's testimony. He said he didn't rely on Trooper Paul's determinations, but he did rely on the underlying data. But the court did not agree. So let's see. Money buys all. So why can't it buy actual experts? Donnie B, I don't know how we got here with some of the wildest experts we've ever seen. I don't know. Betty Ross said, question, was the expert not to take anything from Trooper Paul's report? I speculated that they asked this expert to do everything independently and not use Trooper Paul's report so that it wouldn't come up. That was purely my speculation. They wanted a completely fresh analysis. They didn't want him to rely on anything from Trooper Paul. But there is information Trooper Paul gathered that this expert had to rely on because he did the chip-off testing of Karen Read's Lexus. Karen Read's Lexus, it seems to not be functional anymore based on the testimony we've heard. So they need to know the mileage of Karen Read's Lexus when it was at Canton. That's information they need. So he would have had to have used some of that underlying data. But the defense wanted to get into, but Trooper Paul determined these things. And this witness was saying, I didn't rely on those things. And so because I didn't rely on those things, then the judge is not allowing him to be asked about things that he didn't rely on. I see the defense argument of, but he used all this data, and the prosecution argued, but he didn't rely on the analysis of the data. It's just, that's the source of the data. The defense can still call Trooper Paul. It does not forestall that avenue from the defense. And that's basically what Brennan said in his quite snarky argument was, if they want to call Trooper Paul. So they can. Pharmacist Karopi said, why are they saying arm lacerations instead of abrasions? They are different. Blunt versus sharp object. Shouldn't a biomedical engineer know the difference? Should. I imagine it will come up with ARCA. The big Kapowski said, I like picturing Alessi last night tucked into bed, excited like a kid on Christmas Eve. I'm sure Alessi was exhausted last night and was like, okay, well, we have a plan for tomorrow. But yeah, those kind of cross-examinations are absolutely exhausting. Absolutely exhausting. Melinda V said, it's my 47th birthday. It's a gift to have EDB streaming. Well, thank you. Hope you got other fun gifts on your birthday. And I'm glad court was on today, even though it was short. Froggy Girl said, what happened to a robust cross? The court is arguing that that is an area of questioning that they were not going into. I think that there is room for argument that where the materials came from is open to be questioned about. But if the defense wanted to get into, but didn't when and where the key cycles are change, if he didn't rely on it, and if that's what they wanted to get into, it seems that the court ruled that that goes beyond. What is frustrating about having stuff argued at sidebar is we did not hear the full argument of what the line of questioning the defense wanted to get into was. So I have to speculate it goes beyond just these things all came from Trooper Paul to lay the foundation to bring in Trooper Paul. I have to imagine based on the arguments that they wanted to say these things came from Trooper Paul, and didn't Trooper Paul determine this, 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 and this, and you just threw all that out and started fresh. And then juxtaposed that the timeline of the data is shifting. I think that's where the defense wanted to go with that. But that is not what the court was going to allow, so they have to bring Trooper Paul in. Nick said, why is questioning autopsy hearsay if it's evidence? It's not the autopsy, it's the determinations and the expert's findings, because the witness said he didn't rely on the expert's findings. So experts can testify to hearsay if they relied on something. But if the expert didn't rely on it, he can't be cross-examined about why the coroner did or didn't do something, what the coroner determined, and if that changes his mind because he said he didn't rely on it. I still think it's fair to say the coroner, if it's in the coroner report, if it's not in the coroner report, it's different. But the coroner said these injuries weren't consistent with a vehicle collision. You disagree. Why do you disagree? And he's going to say, I didn't rely on that at all. And I'm a biomedical engineer, so I don't care what the coroner determined. The coroner determinations are completely separate from my determinations. I think there's room to ask about it. The court shut it down, but the jury has also heard very clearly from the coroner. And the coroner said, I found this to be undetermined. And we know how many collisions the coroner has seen. So it's going to be, does the jury agree with Welcher? Do they agree with the coroner? Do they agree with the coroner plus any witnesses the defense bring in that agrees with the coroner? And the coroner's testimony, the testimony from Welcher and the testimony from Wolf can all square with a fall backward without needing any vehicle collision. And I think the Commonwealth witnesses, and the defense will probably argue that the Commonwealth witnesses have shown that you can have the injuries to John O'Keefe without a vehicle being involved. And that squares with a lot of what Welcher said in his experiments of just dropping a dummy backwards. It squares with what the coroner says, and it squares with what the neurosurgeon said. But we'd have to go into argument for that. Jojo said, do you guys get so frustrated and baffled you just start singing? I mean, you see where I'm at with the song lyrics intruding my thoughts. How many debates do you think Alessi won in high school? Debates ran away from him, so all of them were a draw. No, all of them were a forfeit. Debates were just like, no. Terry in the chat said my high school band director would have shut him down yesterday. Yes. I needed more band director energy from Alessi, but Alessi was attempting to let the witness just over explain. And there was some of that. And Dan said, if I was a resident of Massachusetts, I would be so pissed. A lot of them are in the chat. They are pissed. We've seen it in the chat and in the comments. They paid $400,000. I mean, over 320, I can verify, for an independent investigation in which Dr. Welcher used other people's info. And why didn't he do his own investigation? He says he did do his own investigation, but he did need some of that base info. And there was no other avenue to get it. He said he did all his own investigation. He did buy the Exemplar vehicle, which I think was helpful. CSI Can said, I used to think my father was a lunatic for yelling at sports on TV, and then I find myself yelling at this trial like it's a game. Right. You're like, what are you doing? I get it. Could the defense ask for a judge recusal? That happened prior to the first trial, and it was denied. It's generally denied. It is rare that it's not denied. But they asked, speaking of Massachusetts residents, I'm just guessing. CC Medic said, DCI's Dante Inferno show, the emo guard girl heart fulfilled. I will go look. I forget who did Dante's Inferno. I know there was one, but my brain cannot place them together, though I did get to talk to Travis yesterday. And on Wednesdays, we were pink. He was having a great day at guard. The rest of the guard, or the rest of the corps, moved in. And he's like, there's a lot of people. I'm like, there's a lot of people. It's a lot of people. It's a lot of people. But he's very excited to be working. He's like, I knew the days would be long, but it just feels different when you're like living it. I'm like, it does feel different. Enjoy DCI boot camp. Katie said, I trust your opinion. When did your kids get phones? Katie, it really depends on the kid. But T got a phone earlier than G did because before we moved, he rode his bike to school. And I wanted him to have a phone, A, to make sure he got to school, and B, if there was an issue. And one day there was. And he called me. He's like, so I fell off my bike. I'm pretty sure I broke my wrist. I was like, shit. I'll be right there. So that's why he got a phone earlier. G does not have a phone, doesn't need one, but still uses other tech. So I think when it goes to tech and kids, for me, it really depends on the kid. It depends on open communications with the kid, and it depends on what the kid needs it for. Travis needed, I thought, a phone because he was riding his bike to school. So it was important to me. But the phone was not the bigger question for me. The bigger question for me was social media. And that happened later for our kids. Even with Griff does not have social media other than the ability to use YouTube, just because that is what is appropriate for G. So he has YouTube, but not other social media. And most of the kids that he knows also don't have other social media, and they can communicate via a parent texting and messenger. Travis does not use a lot of social media either, and he wasn't asking me for it. I don't know how to answer the question if you have a kid who's like, but mom, everyone is on social media and everything is happening on social media, and I have no idea what's happening because everyone is communicating. I did not have to battle that with my kids. I don't know how I would make those decisions, and I don't judge for how those decisions are made. I do think the conversation needs to happen, but T does not do a lot of socials and didn't even start doing minimum socials until after 16. So that was what's right for him. But T's also kind of he's kind of a punk kid. He's like, everybody doing all this shit for like likes. Lame. So that is where T is on just like, I can't believe these kids and wanting the likes and views. Ew. But he has had Discord before that to communicate with his friends. So it really depends on kid. And I think the more, has T ever said as if? A little bit. B-Man asked, is T allowed to cuss? I do not tell him he can't. We work very much on situational awareness because my kids are also ADHD and impulsivity is real. So we work on situational awareness, and there are times with my kids that I'm like, hey, that's too spicy for mom, or I don't need to know that, or that's a little too much, but I think we have to have the conversation. My huge determining factor for kids in social would be how communicative said kiddo is about it and how willing to be communicative and open they are. That really depends. And then T's social media profiles were private. So having a private account where he can connect with people he knows was different. But my kids grew up with me working as a district attorney. So their presence or lack of presence on the internet has been something they've grown up with since the beginning. But no, there's times T curses and I'm not bothered because there's times I curse as well. But did he curse at like 10? Just be like, what the fuck? Not often, but on occasion. But other times where I'm like, T, I am your mom. That is, I do not need to know. Then again, my kid also does play some online games. And there are times where I'm listening to him in a lobby and I'm like, what are you screaming? Stop it. So it really just depends. And I saw AC in the chat said Discord's a hard no in my house, but I do allow Roblox. And we don't do Roblox with any messaging turned on. So it really just depends. Theorist said, I love realistic parenting. Each kid needs to be parented for them. And you just have to have conversations with them and they have to understand. So T well understands that like what goes online can stay online, but T also has the benefit of being in color guard. He has a lot of female friends, and the way that teenage girls interact on social and the way that they can be awful to each other on social is something he has witnessed. And he's like, I hate everything about that. I hate the way people weaponize things against each other, exclude each other. I hate it. And so that, to just give my kid the ick, that gives him the ick. And he's witnessed it. And he's like, I want no part of this because I've seen how devastating it can be. And I don't want to do that. So he has ways to communicate with his friends that work for him, but he's also not fighting me about it. Communication. Open communication. Just open communication. Your kids, as you become teens, your kids have to trust you. The other way around is important, but they will become teens. Your kids have to trust you that they can come and talk to you. And it is hard. So, and it is different. All right. We have just jumped all the way down to parenting, but it is hard. And it's different because a lot of us didn't grow up with social media and are trying to navigate it with kids. And I can't imagine. I regularly say, I can't imagine going through junior high and high school with social media. I cannot imagine it at all. And it's a lot. So I also tease T. I'm like, look, leave all the doors open. Leave every door open you can. And the less you put on social media, the more doors you are leaving open for the future. So leave as many doors open as you can. You will get to a point where you want to start closing doors, fine. But leave doors open with your grades. Leave doors open with the ability to choose. And there are things you can do on social media that can start to close those doors. Don't close those doors for yourself. Leave them open. Because I think in T's generation, I'm like, there's going to be like 7 of y'all that can even get a security clearance. So just leave the doors open. Too many of y'all have a social media footprint. So you never know. You never know. They're going to be like, anyone. Just go ahead. I think it's also with T and some of his friend group, not being on social media has become kind of a flex. Like, yeah, you don't know what I'm up to because everyone's so overexposed on social. So it's become kind of a point of contention for them. Like, right, you don't know what I'm doing. If I want you to know what I'm doing, I'll tell you. You don't need to know. And so that's where we joke about leaving doors open. Because you never know. You just never know. Jordang in the chat asked, why is Welcher allowed to open his books and notes? He was just, Welcher was just like, I do what I want. Welcher went full Cartman. So Leafy in the chat said, privacy is a valuable currency and becoming more valuable. Mary Peck said, lol, oldest intern for NASA. Yes, clearance is a must. Yes, you never know what you might want to do. And the job market's going to narrow substantially if you need a security clearance, depending on how old you are. Because people have narrowed it all down, especially if they all want to be influencers. They've narrowed themselves right out of a whole lot of jobs. I'm like, look, man, you never know what you might want to do in the future. So, all right, let's continue on with some questions. And then I'm sure Team Baker is going to start pinging me and be like, hey, you have other work we need you to do. Can we take the opportunity, please? Because next week's going to be a mess. Look, our half day is now a half day. Fun. Yes. Glitz and Glitter said I wouldn't have made it through this trial without you. I feel the same way, Lawnards. Do you think Alessi watched himself last night? I know most lawyers hate reading themselves back on transcripts. I have no idea how they would feel about watching themselves on TV, but I wonder if Alessi looked at some of the answers the witness gave and kind of went through the checklist of what he wanted to get to or not. Lily B said, in what circumstances does a judge allow the witness to refer to their own devices to assist their memory and how they answer questions? There is a procedure for it. May I refer to my report? The defense can say, no, you can't. And the court can say, then no, you can't. But if the answer's in the report and the report's been turned over to the defense, then it's generally not a problem. And the court will say, yes, you can refer to your report, but the jury needs to know this is not coming from this witness's memory. This is coming from this witness's notes. But because with experts, the reports have been turned over to everybody, it's appropriate to allow them to refer back to it if they or the lawyer ask. Nicole Ling, thank you for the super chat. Nicole said, when I am in class, I put my phone, iPad, and Apple Watch on Do Not Disturb, mute my laptop because I need to not have the notifications notifying me when I should be paying attention to the person teaching. Agreed. I feel like it should be the same thing with being on the stand. I agree with you. And I know with the iPhone, there was a change that you could leave your screen always on. I turn that off too. I don't want to see it. I don't want my watch pinging because I will immediately be like, ooh, what? Especially when I'm streaming. Though there are times that I do need to address other things that are going on when I am streaming, and we do that too. Let's see. Be your own strong. Emily, on a scale of 1 to 10, how hopeful are you that the defense calls Proctor and AJ can question him as a hostile witness? Me equals 12. I'm interested to see the process in Massachusetts of getting to a hostile witness. And again, a hostile witness is not based on vibes. It means that you called the witness. You, lawyer, called the witness. Generally, you have to ask direct questions. Every jurisdiction has a process for when that witness refuses to answer direct questions that you can then cross-examine the witness even though you called them. So it really should be like opposing witness. You were treating them as a witness from the opposing side, even though you called them. It'll be interesting. But I also imagine that Proctor will try to gamify that so that Jackson can't cross-examine him. So we'll see. Yeah, we will see. Let's continue on. Texas Tooth Fairy said, can the defense impeach this witness? My second question is, will the defense call former Trooper Proctor? I think they will. 56% of you in the chat think that he'll be the first witness. 31% think he'll be the last witness. And right now, with over 12,000 votes, 13% of you think that the defense won't call him. But this witness, a direct impeachment was hard because the witness wouldn't answer anything clearly. But what they will do is oppose this witness with their own experts. Daphne said this lawyer came to class today. He's on fire. Yeah, Alessi was coming in strong. It kind of fizzled at the end there, though. It just, when we got to recross, it was like, Rrr. But Alessi, I think most of his practice is in federal court. I wonder how much of his practice is dealing with witnesses like this. Criminal attorneys know this bullshit inside and out. It happens all the time, and you do high volume trials. With attorneys that are in bigger firms and big law and do a lot of federal, the volume's just not there. And like anything, you need those repetitions because then when it matters, you have dealt with a ton of witnesses that act just like that. So for attorneys that do high volume trials, it's a little easier. For attorneys that don't do high volume trials, it can be harder to find your footing in that strategy with a difficult witness. It really just depends, because Alessi argues like he is talking to the appellate court, and there are times he questions like he is in an appellate court. It is just a different parlance necessarily than state level court high volume trials. But that doesn't make it wrong. It's just different. Alessi is an incredibly smart attorney. His strategy to outsmart is something I don't try to do with witnesses. Then again, I don't know if Alessi is, after the voir dire of that witness, is going to be able to lower that witness's kind of questioning inhibitions by being like, oh, just explain it to me. Because that witness is like, no, I'm on to you. We already did this voir dire together. I see where you're at. So each attorney has to find a questioning style that fits them and then fits the witness. Which is a whole thing. Alessi was going for like straight up, I am smart. There are times that any human that is incredibly smart can struggle to bring it down a couple notches for all of us. So that can be hard. Y'all says he takes effort to cosplay as John, but doesn't think camera model differences are important. Or the suspension. I found the suspension, some people might not. I found the suspension to be an incredibly good line of questioning. Because it matters. And where the injuries are matter. And if it's a variance of, if John O'Keefe can vary by up to 4 inches and the car can vary up to 5 inches, you got a lot of different variances that put those injuries in different places that they can't account for. And it's the job of the Commonwealth to account for them. It's an easier job to say, nope, they can't do it. It's the job of the Commonwealth to account for it. And I would just offer that job is less hard depending on the case. Did it feel like the prosecution had a hard job in the Sarah Boone case? Or did it feel like the hardest job the prosecution had in the Sarah Boone case was dealing with Sarah Boone? It didn't feel like it was a fight to prove what happened. Same with the Brooks case. It's not a fight to prove what happened. You're like, I mean, okay, what are they going to say about it? And you can see it across different trials, depending on what the facts of a specific case are. With this case, everything is a fight. That's because the case is not clear for me. Let's see. Miss Meg says, I am the captain now. Yeah, I went with I'm in charge now, Phasma, but yes, I am the captain now also works. And my mom said, EDB, thank you and Team Baker and your mods for creating a place where we can watch and learn that is safe. We appreciate y'all. Yes, we are not here for the thunderdomes of the internet. Because, again, as my friend Rick Hogue says, reasonable minds can differ and we can have conversations. People are going to see the evidence differently and the witnesses differently and the attorneys differently. But we can do that in a way that respects one another because everyone's going to see things from a different perspective. And that's a good thing. That's why jurors aren't just one. That's why there's 12, so they can discuss it. And I love having those conversations. And I see it from the perspective of somebody who practiced in court for a really long time. I expect y'all who have had different life experiences to see things differently than I do, which is totally fine. I try to break it down as best I can from how I see it and how others might see it, because that's what my brain is trained to do based on my experience. But I don't think that means you should see it the way that I do at all. Because again, the lawyer's job is to tell 12 people how they see it and see if those people agree. They may not. But I don't see that as my role here. I see my role here as, this is how I'm seeing it. These are good questions. These are not good questions. This is the strategy that I'm seeing here. This is the strategy I'm seeing there. This is where I'm seeing this witness doing well. This is where I'm seeing things I don't like from this witness, and the jury's going to fall somewhere in between. Much more commentary, much less advocacy. Unless it's a case that I hate. You catch me talking about the courthouse Becky case, and that's going to be a different vibe. Emily, is it commentary? Yes, but I have very strong opinions. So very, very strong opinions. Let's see. The real Chloe in the chat said, Alessi want me to bite him. This witness walked out of court thinking that, I'm sure he was also tired, but I think this witness thinks that he won at cross. What do you guys think? I think the witness thinks he won at cross. It was just like, That's what I think. Let's see. Alexis in the chat said, I can't believe I slept in today. Catch me up with what I missed in a single sentence, please. I really want to look at my computer. I'm amusing myself imagining if this was Jackson. I think Jackson would have lost his mind on this witness and it would have been bad. And I think that Alessi was the right attorney because you did get in some points. The fighting between this witness and Jackson would have been a more of a shit show. And I don't think we would have even gotten any of those answers in. Alessi made headway, but it's headway that's foundation for other things. It is not necessarily boom goes the dynamite headway, but both are important. Oh, this is not a My Cousin Vinny scene, sir. Oh, he definitely thought it was. He was full main character up on that stand. So, CryptKey VT said, it's not Photoshop. It's a highly technical, fancy Photoshop. Yes, they overlaid it. They overlaid it, not Photoshopped it. Overlaid it. It was a lot. Dawn the Sleepless Hag said, lasers don't like shiny objects, but us neurospicy do. The lasers don't like shiny objects was one of the wilder answers that we heard. But then yesterday we also got bones are inside your body. So, you know. Emily, is it wrong that I want Alessi to say, answer the question, Claire? No, it's not wrong at all. I would also be entertained. Would Alessi do that? No. We heard Alessi actually snark today. Like, that just broke Alessi. Alessi was just like, he was done. He was done. And you could see it. Pissed. Which was also amusing. Spicy Alessi is rare, but it was amusing. But you don't want the witness to think that you've lost your cool, even if it's for dramatic effect with the showing the jury that they should be annoyed too. Because this witness thought that he won when Alessi was frustrated. You could see it on his face. He was just like, difficult witnesses. Enjoy that game. It's like fighting on any text-based platform with someone who loves to fight and you don't. If you don't like engaging that way and the other person does, it's a loss for you no matter what happens. Is it Rob that has said frequently, I think Rob at Law and Lumber says frequently, when you're wrestling with a pig and shit, only the pig enjoys it? Right. When you are having that kind of interaction with somebody who loves interacting that way, you're going to lose either way if you do not. And Alessi does not. Alessi is very much, can we just logic our way through this? And I ask you questions, you answer them. That is how this goes. Society has rules. We are in a courtroom. And this witness is like, nah. What about this? What about that? That's not quite right. I'm trying to help you here. Help me help you. Yikes. Yikes. Help me help you. Ew. Hated it. Hated it. Hated it. Deb said, really enjoy your input here, Emily. You call it like you see it? Yes, I do. I see that as my role here, and then to try to explain the strategy the best I can and tell you when I can't. That's my goal. Christopher said, I'm baffled by the decision on the ME report. It's already in evidence, so it wouldn't be usable for all purposes. This witness said he didn't rely on it. And so depending on what the defense wanted to ask, it's going to matter because the witness didn't rely on it. But also, yes, it's already in evidence. So the defense can just make the argument. He didn't even want to consider other variables. He didn't want to consider the ME's report. He didn't want to consider any of this. He wanted to consider what he wanted to consider to get to his result. And you leave it for argument. Alessi doesn't want to leave things for argument, which I get, but there are things that are just going to have to be left for argument. And if the defense is already concerned about the amount of time they have for closing argument, I understand the pressure of every point can't be left for closing argument because there's simply not going to be enough time. And that is a real concern in this case. Let's see. I'm just going to get into a few more questions and then we're going to take a break for the rest of the day and get stuff done. Spock's Brainworm said, if I paid for this guy's fees with my taxes, I'd be furious. I think the residents of Massachusetts in the chat have said that. Dawn said, my son is a Lexus Master Tech. He calls BS on this guy. And they didn't call in anyone from Lexus, but I saw some of the chat saying today and yesterday, maybe I need to go buy a Lexus if it can just like rocket off into space. It seems like that might be awesome. So we'll see. Let's continue with questions. Oh, thank you. Thank you everyone who was talking about all of the loads, how direct or indirect they may be. I appreciate it. They can't use WhatsApp then, that's encrypted. Alessi was laying the foundation to try to say that ARCA had done something that they shouldn't do with the messaging. So, Emily, did you ever consider being a defense attorney when you were practicing? I did not. I specifically considered becoming a prosecutor. This is going to shock all of you, chat. Prepare your shocked face. I like to make my own decisions and have control of the things I am doing. The prospect of being told this is the case you are going to take and this is what you're stuck with and that prosecutor is making all those decisions does not sit well with my personality. You have a bit more control of how a case is going to go forward as the prosecutor. As the defense attorney, you really have to respond to what they are doing or deciding to do, and it would make me lose my mind all the time. Having the ability to make those choices of cases to bring, cases to not bring, at times cases to file, cases to not file, witnesses to call, witnesses to not call, to advocate for cases to be dismissed if they'd already been filed, that level of choice was important to me. It didn't mean I got to choose all of my cases, but you have the ability to choose how a case is going to go forward. The defense does not. And that was a big factor for me. I also had experiences with victims early on in life and my own experiences where I looked at things my friends had experienced and went, I can do that better. I can do that better. And I saw room for me to help. And that's what I wanted to do. And all of my friends that are in defense saw room for them to help. And they're like, no, I can be a shield. I see room for me to help here. So I saw room for me to help. So also, I very much like to have control over the things that I'm doing. Emily, how do you pick what cases you want to talk about now? I'm going to talk about the cases I want to talk about. Even if all of my DMs and emails and stuff blow up about a certain case, if it's not a case I want to cover, we're not covering it. Even if everybody wants to cover it, we're not covering it. I cannot tell you the amount of times other content creators have been like, oh, you should cover this case. I bet the views on that are insane. Not others in this genre, others in other genres. I'm like, I don't want to talk about that. I don't want to cover that. That sounds awful. I want nothing less. Yeah, but people want you to cover that. No, I don't want to cover it. If I don't want to cover it, I'm not covering it. Period. Control. Self-determination. Mary in the chat asks, Emily, are trials ever limited to a certain time frame? In civil, they are. In criminal, not so much. There can be times in criminal, like there's a little asterisk to that, depending on the jury and how the jury's qualified. But in criminal, not so much. In civil, 100%. And we've seen that. So let's see. For Mini-Me's says, maybe an unpopular opinion, but these clips will be the nail in her coffin, I fear. The clips are going to be substantial. The clips of Karen Read are going to be substantial for the jury. The jury wants to hear what a defendant has to say. And the defense has to work with those because the clips of her interviews are going to be a substantial factor for the jury. They just will be. No matter how people see them, with knowing a lot about this case, the words the defendant says, how a defendant acts in court, what they wear, how they sit, who they talk to, their facial expressions. It's what the jury is keyed in on most of the time. If she testifies, then the importance of the clips will go down because her testimony will be the thing. But what the defendant says carries a lot of weight. I agree that the evidence has to support it, but I know that what a defendant says will carry an outsized amount of weight to other things in a trial. And the defense knows that too. There's a lot of lawyers on the defense team that are aware, and it's something that they are going to work with. They're going to have to. So, absolutely. They're going to absolutely have to work on it. So, let's see. I think the defense will have a compelling case. Kel, there's a lot for the defense to work with. Not every case has so much for the defense to work with. There's a lot for the defense to work with. But they're going to have to also work with those clips. I agree. The clips are being used like depositions. Essentially, they are just recorded statements of the defendant. Celine Adams said, first-time trial watcher, I don't know anything about her outside this trial, but that clip has changed my mind. She just told me what happened. And Celine, you're not going to be alone in that. And I think the opinion on this, and this is my speculation, I think the opinion on that will vary based on how much people know about the case. I think there will be a wide variety of opinions, 100%. And I also think that may change as the defense gets into their case. There's a reason the Commonwealth left that clip for last. They think it's damning. We will see how that holds as other evidence comes in. Jake B said, can the defense call the interviewer to get the question being asked to add context for her response? I don't know if they would want to highlight it again. So they could, but then they couldn't get into Reed's statements. But if they call the interviewer and say, what question did you ask Karen Reed before this answer? They highlight the answer again. They show that they're worried about it. The jury sees it again. And then Brennan gets to cross-examine the interviewer and ask about it over and over and over again. So we will see. Let's see. Cindy Hawkins said, if they bring back Welcher, I may have to pause my launcher. It's fair. You can watch the summaries on the Emily Show podcast. Kristen Palmer in the chat said, can they call a family member to discuss her state of mind? No. They would have to call her to discuss her state of mind. So, Robin said, I think seeing Arca back-to-back with Welcher, you see the difference in the competence between the two. Maybe. I think it keeps the jury in the same train of thought with the accident. But if you want to ultimately argue that this investigation was flawed from the beginning, I see bringing in Proctor at the beginning to show from the beginning of the investigation what happened. So I can see it both ways, but I agree. Let's see. If the defense calls Proctor, could they bring the FBI case? No. There isn't an FBI case. There was an investigation and a grand jury, but the jury's not going to know about the investigation and the grand jury more than they've already heard. So no, and not with Proctor. They can bring up Proctor's discipline. They can bring up Proctor's discipline if they want to. Donnie B said, EDB, I heard a rumor they aren't calling Proctor. They might not. They don't have to. They have a lot of decisions to make, because here's where Proctor can go sideways for the defense. Why let him explain? Why give him an opportunity to explain? Is it the strongest argument to say, well, what did the prosecution show you or not show you? There are two ways that can go. Kathy asks, is Proctor even on the defense list of people to call? The defense witness list incorporates the entirety of the prosecution witness list. So, yes, the defense can call anyone on the prosecution witness list should they choose to. Thank you for the gift of memberships. Is the defense limited on how many witnesses they can call? K9s, no. Asterisks. You cannot call unduly cumulative witnesses. That's not going to be an issue in this case. But no, they're not. They can call the witnesses they want to call. They cannot call 17 witnesses to say the same one thing, but that's not going to be an issue here at all. Let's see. Cassie said, after 22 years as a nurse, I'm finally a CCRN. Congratulations. Congratulations. Sandra said, after that last clip, need ARCA to go first to say there was no hit. And that's what, hearkening back to what Jackson said in opening. Kel said the prosecution's case was so messy, the defense witnesses are more professional. I think that alone will be compelling. It depends on how the jury perceives the defense. There are a lot of jurors that think the defense is trying to trick them at every turn, no matter what. So if the witnesses are too smooth, it can also turn off the jurors. Again, I was surprised hearing jury interviews from the last trial that the jurors just discounted ARCA entirely. I found ARCA to be incredibly persuasive. So you never know what jurors are going to do. We can guess at it the best we can, but sometimes when witnesses are too smooth, it can be held against them because it feels too polished. But I think the prosecution left out quite a lot this case, and the defense may be able to shift that back onto the Commonwealth. What are they hiding from you? We're not trying to pull anything over your eyes. What are they hiding from you? And that's a strategy that the Commonwealth has to be mindful of. And I think that they are mindful of it, right? Can the Commonwealth prep Proctor if he's called by the defense only so much as they can prep any other witnesses? I don't know if they will. I think it might be stronger if Proctor has his own lawyer, which I imagine that he does, to let him work with his own lawyer on that. But we'll see, because then you will. What was I answering? I totally lost my train of thought. Oh, if you let Proctor's own attorney prep him, if you say, we think the defense is going to call you on this day and that's it, the defense will say, did you talk to the Commonwealth? And he'll say, they told me what day they thought I was going to testify, and that's it. And you let the attorney talk to him. So that is what I think. Because Miguelina let me know that there was a video that we needed to watch real quick before we wrap up questions. Thank you, Miguelina. You were the best. I appreciate you. Let's pull that up real quick. From statements after court today, because court has now been done long enough that we can look at statements after court today. I appreciate that. So let's take a look real quick at statements from after court today, and then we're going to wrap up. Annie said, excited by Metallica and is Saturday in Charlotte. Enjoy. Have the best day. Emily lives for concerts. We love it. We love it so much. All right. Let's see what Karen Reed had to say after court. And thank you for everybody who let us know that this existed and everyone for finding it, because I'm sure it was a team effort. Thank you, team. So this is after court today, after the prosecution rests. This is vertical video, so just, well, it just is what it is. Vertical video. All right. Let's see what is said after court. I don't know how loud this is. It sounded kind of loud. But it's outside.
Karen, what can we expect from the defense? Will you testify?
TBD. How long will your case last?
I thought that they hadn't decided yet. I'm not surprised they haven't decided yet. I think that's 100%. 100% TBD.
1.5 to 2 weeks. How are you feeling after today?
That's what
I
they
feel
said.
very good, thank you.
Will you call Trooper Paul? Is that the only way you can get his testimony in at this point?
Will you call Trooper Paul? Pause. Is that the only way you can get his testimony in at this point? Yes.
If you do?
It seems that way, yes.
Any
Yes.
decision
So
about
you made that
Trooper
decision?
Proctor, Karen?
TBD.
Paul's coming.
Any decision about Trooper Proctor? TBD.
Oh, guys. Oh.
Any idea who the first witness will be for your defense?
Not just over.
Oh, DeSogra, their tech expert. All right. Well, I guess we get to end the poll now. Their tech expert will be their first witness tomorrow. Disorder, that one. Their tech expert. That makes sense. I still want Proctor to be called first. So I guess we'll see Disogra. Donnie in the chat said TBD, to be determined, haven't decided yet. Disogra, disorder. Who we've heard a lot about in the pretrial motions. That made sense. Can the tech guy read in texts? Not necessarily. If they use the text for timing, they can say there was a text and this is for timing. But can they read the text in for what it says? No, they can't, unless it's their own text. All right, and that's the end of that. So it seems like the tech expert will be, based on Karen Read's statements after court today, it seems like the decision on Trooper Proctor is TBD, and that their first expert or their first witness tomorrow will be their tech expert, who is going to talk, I imagine, about the timing of everything that we've seen from Welcher to Jessica Hyde. That's probably a multi-day witness right there. Does it surprise me that that's their first witness? Well, I wanted it to be Trooper Proctor. Why? Because that would be fascinating. Does it make sense to lay out where the time variances are before you call the rest of your witnesses? Sure it does. And what about Trooper Proctor? Well, Karen Read said after court, that is still to be determined. And her testifying is still to be determined. That I don't doubt. That is a decision that you have to wait and see how things come in and what happens. But the prosecution is, it feels to me, using the clips to almost push that. But they can use those clips for whatever they want, because the ultimate choice to talk to the media or not talk to the media was with Karen Read. Once you talk to the media, the prosecution can choose how to use it. And they're going to. And they're going to use it to make everything look as in a line with their view of the case as they can. 100%. Which is going to happen with just about any lawyer of anything. They're going to say, well, this is how I see it. You should see it this way too. Lawyers can argue one side and down the other. That is the job. Let's see. Lisa said, last night, Avril Lavigne with daughter in Syracuse. That's so fun. Best show, Dance to Girlfriend. Just Dance Moves first song. Great show. That's a lot of fun. It is summer concert season. It is summer concert season. How long till code bra tomorrow? At some point, we will get to a code bra. For sure. We have lots of them. Law nerds, I appreciate you. Angela said, I don't think Karen will testify. She's teasing the media, in my opinion. I don't doubt that they haven't made that decision yet. You just have to see how things come in and then make that decision. So I don't think they've decided 100% she's not testifying. I think they probably have said, we would like to not testify, and these might be the circumstances when we change our mind. So I think they are probably keeping that possibility open. Law nerds, it is great to see you. I'm going to get all the things done. We'll see how long our court day is tomorrow, and then we will talk about, the rest of the week tomorrow, what we are doing next week. We've got some travel coming up and all the things. So law nerds, take care of yourselves. Use the early day to get some stuff done. I sure am. I hope you do too. I will see you in the chat tomorrow bright and early, because I want to hear that. Emily, do you really mean it? Yeah, I want to hear that argument. I want to hear argument tomorrow. I really want to hear their argument tomorrow. So let's I might set the stream a little earlier, pop on a hat, and just roll, because I'm really interested. Emily, are you going to use the early done today to be early tomorrow? Yeah, I want to see their argument, like IRL. So I will see you tomorrow. Make sure you have the Law Nerd app so that you will be as on time as I am. We'll all just be here together. And if you haven't caught up on the Emily Show podcast yet, the Emily Show podcast lives on your favorite podcasting apps and on the Emily Show channel. Go check out this week's episode. We talk about everything that's going on in Idaho, because things might be changing in the Koberger prosecution as well. So go check that out. And I will see you tomorrow, bright and early. Law nerds, the prosecution rests. We're in the defense case. See you in court tomorrow. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.